Court and Supreme Court judgments, latest updates on Karnataka RERA. To speak this, we have two eminent speakers, our own fraternity member, CA Ramesh S. Prabhu sir from Mumbai and CA Vinay Tyagaraj sir. Welcome you both of you, sir. As you all know, the Real Estate Regulation and Development Act 2016 is considered as one of the landmark legislation passed by the Government of India to reform the real estate sector in India, encouraging greater transparency, citizen-centric accountability and financial discipline. This is in line with the vast growing economy of India, as in future many people will be investing in real estate sector. Considering this, to plug the loopholes and so many issues in real estate sector, in 2016, Government of India is come out with this landmark legislation. After that, lot of reforms and updates has been happened. To have that updates and knowledge under High Court and Supreme Court judgment, to speak on this, we have both eminent speakers. I welcome you both once again, sir. And one special note about Institute, by this weekend, 25th, 26th, 27th, 28th on May, we are conducting a workshop on GST, 4 days workshop on litigation practice, how to address show cause notice, departmental GST audits, so many other litigation aspects has been organized for 4 days workshop. It is purely on a physical basis, not on virtual. I request members to join. With this information, I once again welcome you all. Over to our Secretary Pramod.
Thank you, Chairman. Well, I would take this opportunity to introduce Mr. CA Ramesh S. Prabhu, who is a practicing chartered accountant who is qualified with an experience for more than 3 decades and whose opinion is sought on various laws and issues, particularly in RERA and cooperative sector. He is a regular faculty and task force member with the Institute of Chartered Accountants of India. He is the co-opted member of Cooperative Committee of Maharashtra by WIRC of ICI for the last few years. His practical in-depth knowledge of cooperative and housing sector, he is the author of 40 books issues on like conveyance, transfer of flats, parking, collection, dues from members, and he has authored 4 books on RERA covering all the important features thereof. He is also the editor of WIRC Maha-RERA Practice Manual by WIRC, which he is the editor of MSWA Housing Societies Review, having circulation more than 35,000 copies, with readership over 1.5 lakh across Maharashtra state. He was appointed by the government of Maharashtra in 2008 on its committee for drafting the law for deemed conveyance. He was invited to discuss before the Parliament Committee of Government of India to discuss draft bill of RERA, and most of his suggestions were incorporated in the final approval of the said act. He is the member of the committee of the government of Maharashtra to include a separate chapter for cooperative society in the MCS Act 1960 MCS rules. He has become synonymous with the housing society, redevelopment and RERA matters in Maharashtra. His authored book on self-redevelopment released by Sri Uddhav Thackeray, CM of Maharashtra in February 2020. I would also like to introduce our second speaker of the day, Mr. Vinay Tyagaraj, who is a fellow member of the Institute of Chartered Accountants of India and LLB by qualification as well. He was the founder partner of Messrs. Venu and Vinay Chartered Accountants, having 20 years of experience in taxation and business consulting, chosen his practice on RERA since 2016. He is a guest speaker at CA Institute and Management Colleges. He is a regular panelist for Kannada and regional news channels, published articles on financial RERA topics in All India Radio, newspaper, institute journals. His co-authored book, RERA Law and Practice. He's practicing RERA since June 2016 and gained practical experience over 5 years, conducted more than 200 workshops, webinars across South India to various members of the associated CREDI, National Real Estate Development Council, Telangana Builders Foundation, Federation, CS Institute, Architects Association of India, Institute of Engineers, National Law Schools, and Home Buyers Association, etc. With this brief introduction, I would like to hand over this occasion to our speakers of the day. I request Vinay to pitch in, and over to you, sir.
Thank you, Pramod. Thank you very much for a nice introduction. Very good evening to everybody. It's our pleasure to present the today's topic on RERA. We have with us Mr. Ramesh S. Prabhu, is a senior chartered accountant from Mumbai, and it's our privilege and our privilege to have you here, sir. And for the members who are present here, sir is involved into the RERA since its drafting stage, and we will have a good input and insight from Ramesh sir. Sir, thank you for taking your time and being with us in spite of your difficulties in your health. Thank you so much, sir. Looking forward to hear from you.
ಥ್ಯಾಂಕ್ ಯು. ಗುಡ್ ಈವ್ನಿಂಗ್, ನಮಸ್ಕಾರ. ನಾನು ಕರ್ನಾಟಕದವನೇ, ಕನ್ನಡದಲ್ಲಿ 2 ನಿಮಿಷ ಮಾತಾಡ್ತೇನೆ. CA ಶ್ರೀನಿವಾಸ್ ಟಿ ಚೇರ್ಮನ್ ಹಾಗೂ ಪ್ರಮೋದ್ ಹೆಗಡೆ ಸೆಕ್ರೆಟರಿ, ವಿನಯ್ ತ್ಯಾಗರಾಜ್ ಅಫ್ಕೋರ್ಸ್ ಕೋ ಸ್ಪೀಕರ್. ನಿಮ್ಗೆಲ್ಲ ನಮ್ಮ ನಮಸ್ಕಾರ. ಕನ್ನಡದಲ್ಲಿ ಕಲ್ತಿದ್ದೇನೆ. ಮುಂಬೈಲಿ ಬಂದು ನನ್ನ ವ್ಯವಸಾಯ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ನಂತರ CA ಆಗಿ CA ಅಲ್ಲಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅನ್ನು ನಾನು ಪ್ರಾಕ್ಟೀಸ್ ಏರಿಯಾ ಅನ್ನು ತಗೊಂಡಿದ್ದೇನೆ. ನನಗೆ ನೀವು ಮೌಕ ಕೊಟ್ಟಿದ್ದೀರಿ. ಐ ಥ್ಯಾಂಕ್ ಯು ಫ್ರಮ್ ಮೈ ಬಾಟಮ್ ಆಫ್ ಹಾರ್ಟ್ ಫಾರ್ ಗಿವಿಂಗ್ ಮೀ ರೆಗ್ಯುಲರ್ ಅಪರ್ಚುನಿಟಿ ಟು ಇಂಟರಾಕ್ಟ್ ವಿತ್ ಯು. ದಿಸ್ ಇಸ್ ಅನ್ ಅಪರ್ಚುನಿಟಿ ಫಾರ್ ಮೀ ಟು ಇಂಟರಾಕ್ಟ್ ವಿತ್ ಮೈ ಓನ್ Kannadigas. Thank you once again. Today what we will do is that RERA, there may be some new people who must have joined as a beginner. So my entire presentation has been divided into 3 parts. The first is how the RERA working is doing and what are the silent features, maybe 5 to 6 slides. Thereafter, how the RERA has evolved with the help of Supreme Courts, High Court judgments. So this is how I'll be putting a foundation. Of course, because of my little health problem, I'll be requesting Vinay Tyagraj to give the presentation which has been prepared by me. Each slide has been prepared minutely by me. He will definitely give a presentation on my behalf, and whenever he thinks that I need to elaborate, then I will be interjecting or intervening and giving further explanation. Of course, I will be there for question answer also. Now, as I said, the first part is going to be the status of implementation. What is the update for the last 3 years? And then I will be dealing with the various case laws, and that of course I will deal with it. How each items or the sections which have been discussed at different level has been now settling. Now let me, next slide you can take. Let me tell you, the RERA is becoming a very important region, as Srinivas has already said, because this is something going to be like a SEBI, and there is enough opportunity for a chartered accountant to start with. I call it as a 4C. Why I call it as a 4C? First is consultancy. Any law comes, a CA need to have a consultancy, create an awareness. Second is compliance, which of course in detail Vinay will take you through. C is complaint addressing. That means redressal of complaints. And the fourth is complex issues. See, the real estate, the government has intervened at different levels, and real estate has become a complicated subject because after the demonetization, more and more things have become stringent. Then RERA has come in, IBC has come in, GST, interplay of the various laws. Being an economic law, a chartered accountant can better address. No doubt, if there is a litigation, maybe one may go to the advocate. But chartered accountant is being in such a role that entire management of the project, from the registration, compliance on quarterly basis, thereafter managing the fund flow, each withdrawal of the money which is received from the allotee, 70% withdrawal, is signed and approved by the chartered accountant. Now, in the beginning, the certificate and compliance audits were very simple, but now what government has done, the government has been making it more rigid and stringent. To tell you, Gujarat RERA has gone one step ahead. All the certificate generation, uploading, everything is online, and we have to fill up the data there on the website and then download and create a certificate. So it's so important for people to understand that things are becoming more complex. Now in Maharashtra also, what was introduced in 5 years back, now it has changed. So there are so many GST, income tax, NBFC, liquidity crisis. These are the various issues which has created complication. Next. Now, as I said, the working of RERA, if I have to tell you, there is a competent authority which used to pass the plan. We used to give the sanction of the building, and then thereafter they used to sell the flat, enter into agreement. This was there. So in addition to that, now to regulate the real estate, regulatory authority has been set up. To avoid the compensation, adjudicating officer has been set up. And if these two people do some mistake in the judgment, then appellate tribunal has been set up. The entire plan, everything will be disclosed. It is an online mechanism. Next. So this way, this is a entire working which has been given a very sound footing, where chartered accountants are considered as extended arm of a regulator. This is very important for us to understand. Next. Now the project completion also very important. Now I think Vinay, you can take over from here. Thank you very much.
Thank you, sir. Thank you, Ramesh, sir. Hope I'm audible. Pramod, hope I'm audible.
Yes, sir. You are audible.
Yes, sir. Yes.
Okay, thank you. Fine, sir. Okay, thank you. So, in continuation to the Ramesh sir, as whatever he mentioned, I'll go through the few of the important and very mandatory information that one should know as a professional who would be practicing on RERA or would be taking this subject itself as a for the purpose of their knowledge. So one is to RERA was enacted to ensure the regulation and development and promotion of the real estate sector in an efficient, transparent, and accountable manner, and to protect the interest of the home buyers. Friends, the Act name itself talks about Real Estate Regulation and Development Act. It never talks about only a regulation act. It's a regulation and development act. That means to say that there is a concept of development of the industry itself. And if you sensibly and if you curiously know what are the development activities the authorities are undertaking now, is there are various. Maybe in the subsequent slide, I'll try to explain those aspects also. But however, at this point of time, what everyone experience, whether it's a real estate builder, whether it's a professional, whether it's a home buyer, what everybody is experiencing, that the industry, the regulators are only regulating the industry. Maybe you might have experienced your clients, sir, we are not getting the registration in time, we are getting the notices, and they're imposing the penalties on the builders, and also home buyers are clueless about their refund and compensation. Yes, so all those things are all regulations aspects of the industry authority. Of course, there are section 32, 30, 32, 33, 34. Those are all part of the functions of the authority, where they have a mandate to develop the industry, and the functions or activities they undertake to develop the industry. So in an efficient, transparent, accountable manner, and to protect the interest of the home buyers. You may ask, is that there was no efficiency in this industry? Was not there transparent and there was no accountable? I cannot say that it was there and it was not there, but in an the aspect of this act and the objective of the act itself talks about efficient, transparent, and accountable manner. So look at those aspects of this industry and see that what can be brought in by everybody, all the stakeholders, including the professional as a chartered accountant. What can I bring into this industry and this statute in terms of achieving the objective of efficiency, transparency, and accountable. This is a transformative legislation, as our chairman has already mentioned in the introduction speech. It's a transformative legislation, yes, to address the vital issues of a fair transaction, timely delivery, and quality construction through speedy adjudication of disputes, thus empowering the home buyers. So one thing we should know that, like maybe it looks like this is an act which only to protect the home buyer. And of course, because the major stakeholder and the person who plays a very vital important role in this industry is a home buyer. However, However, the powers or the relief which he had was very poor, and he was the last person to get, if in case if anything happens into this industry or to any project. Keeping that in mind, the legislation has been framed, and also it has a very inbuilt mechanism to protect every stakeholders in the entire ecosystem. So it's a transformative legislation. Yes. Why is a transformative legislation? Maybe in the subsequent slide we can see that, because even though Act is a very small Act, it has about 92 sections, and if you look at the entire Act is not more than 30 to 40 pages, and entire 30, if you read of 30 to 40 pages of this Act, you come across that entire real estate industry is there in the Act, whether it may be a registration part, marketing part, launch part, financial management, quality, construction, operation, delivery, post delivery of and formation of the association, management of the funds, how do you hand over, when do you hand over. So every aspect of the real estate project and the transaction between a builder and a customer, and we call it as a promoter and the allotee, is entirely captured throughout this Act. So I can say it's a really a transformative legislation, because it took a 7 decades. It took a 7 decades for the government to come out with a legislation for the specific industry. And of course, it's a word to have this even after 7 decades, because this being the land related laws are belonging to the state. So central government has to intervene, bring every state into a one platform, convince them, and have a central act in turn where states will have a jurisdiction to monitor, supervise, and regulate the industry itself. Enactment of RERA marked the beginning of a new era in real estate sector and step towards reforming the sector, encouraging greater transparency, citizen centricity, accountability, and financial discipline. Very true. You might experience, most of the participants must have experienced this. Each of these wordings of this paragraph, encouraging a greater transparency. You can see now, you can log into the RERA website to look at a, say, a real estate project, what information is available in the website, whether that was available prior to the RERA implementation, whether the buyer or the customer had entire picture of the project details in his hand, whether he had a picture of what is happening in the project, what is the real progress of the project, and whether the money which has been collected has gone into the project, or was it diversified into some other things. And also accountability means in terms of the quality, in terms of the financial management, in terms of the delivery in time, in terms of the interest in case of a delay payment, delay delivery. So entire aspect has been brought into the RERA to protect the home buyers at first front, and also to ensure the business, the builder, the promoter should not get away from the track of his business of having collected the money, having invested. Friends, we have seen that many of the promoters or builders are out of the track, out of the business, for the simple reason that they could not manage, they could not financially manage the project. Here is a law. If you strictly follow this law, I can confidently tell that the promoter, at least the 95% of the promoter will not go bad throughout their project. To that extent, this act has dictated, the act has inbuilt provision to manage the real estate project itself. To have this, there is a structure, there is a authority, there is adjudication mechanism, there is appellate tribunals for speedy disputes of the resolution, which section 22, section 72 has in detailed provision about it. Friends, we all know that in case of a dispute between the customer and a builder, a promoter and allotee, the relief what he had was the approach, he should have been approached to a consumer court or to a civil court, and it used to take its own time the moment it goes to a civil dispute. And here is a law, within 60 days of filing a complaint, the authority has a mandate, adjudicating officer has a mandate to dispose the case, and further 60 days of the appellate tribunal. In matter of 120 days, we can see a order wherein there is either a admission or a rejection of the whatever the relief which can be claimed by the allotee in a project. Similarly, Even the promoter has a right to complain on the allotee under the act. It is not a one-sided, it is a two-sided, where the allotee and the promoter both can file a complaint before the respective authorities or adjudicating officer. And also also important to know that RERA extends to every aspect of the real estate project. It may be a residential, it may be a commercial, it may be a plotted development, it may be a mixed development, it may be an industrial use, it may be anything. You say that it not only for a sale, and also in case of a long lease. In subsequent slide, we'll see the couple of case laws in relation to that. So it includes every aspect of the real estate transaction which covers under RERA, and in case the project is for purpose of sale. Also, if you see that the section 3 mandates in case of a project land is having more than 500 square meters or number of apartments is more than 8 is applicable. I mean to say that more or less most of the projects are covered under this statute and this regulatory mechanism. And also, as we know that this act is not only for the purpose of promoters, and also a stakeholders which involved is the agents, channel partners, brokers, whatever name you call, they also have a key role in role in terms of this industry. So there is an inclusion of a real estate agent under this act under section 9 and 10, where they also have an important role to play under this under the industry. So it was very apt to bring them also under this statute and also make them responsible in terms of their job, their functions, and their duties under the act. Section 13 is a very good, because this is what initially what you have seen is a transformative statute legislation. There was no standard. If you ask me what was the standard of this real estate industry, there was no standard. It is between a demand and supply. There is a requirement and a marketability. The industry used to operate in its own way. If there is no standard of anything, a standard of measurement. If you ask me what is the standard of measurement under real estate, there was no standard for real estate measurement. Somebody may sell at carpet area, somebody may sell at built up area, somebody can sell at saleable area, somebody sell at super built up area. So what do you mean by the standard of measurement under real estate? Now under RERA, it has become mandatory to follow a carpet area. This is a standard of measurement. In case if you wanted to purchase a diesel liter, you have a liter is a standard of measurement for purchase of diesel. So for real estate now, it's a carpet area is the unit of measurement, which is a standard of measurement for the purpose of real estate. So this is one of the example for a transformative legislation. Section 13, which talks about you cannot collect more than 10% of the unit cost before the builder enters into an agreement for sale. Earlier, we used to see, I as a buyer, you as a buyer, you have experienced that unless the customer pays 20-25%, builders were never entered into an agreement for sale. So now it's a 10% standard across India. Statute Act is clear on that, and most of the states are insisting on this. Most of the regulatory authorities are holding responsible the builders in terms of strictly follow this. And with reference to this, if you refer to the chartered accountant certificate we issue as a chartered accountant for the purpose of withdrawal of money, or maybe annual audit, or maybe a completion certificate, you have seen this column called money received, total agreement value, money received, receivable, whether agreement had entered into or not, or whether that agreement is registered or not. So this is what is the important of it. As a professional, we should see whether this section 13 is complied in all aspects while we issue the certificates. So this is also one of the transformative legislation. And the project details to be furnished before registration. Friends, imagine whether you had any idea whether to know what is that the terms of this terms of the agreement while you booking it, or while you decide that you wanted to buy this property, were you able to know what was the terms of this agreement? Most of the time builders used to say you pay the amount of say 10%, 20%, 25%, then only we'll share the copy of the agreement. Now log into your website, RERA website. You can see agreement of sale. which is standard agreement of sale for that project, with entire details of the project except a allotee name, except the unit number, except the commercial aspects of it. Entire aspect of the transaction is captured by way of agreement of sale, and which is available in the RERA website for that project. Section 4 mandates, Section 4 of the RERA Act mandates to provide all this information: the booking form, allotment letter, agreement for sale, and a draft sale deed. So have you seen that these documents before even you choose to select, before you choose to identify a project, and what are the grounds, what are the aspects that you select a project? These are also maybe a grounds for somebody to select a project before even they decide which projects to they go. So that means to say it's a standardized again. Agreement for sale is a standardized. Section 13 refer to the respective rules. In Karnataka, Rule 8 and Rule 8A is notified in June 2020, wherein agreement for sale is a mandatory document, and also clauses are also mandatory according to this. No one can travel beyond these clauses which is mentioned in the agreement of sale. Recently, you all aware that there is a buyer builder agreement. The agreement of sale we commonly call it as, but legally it is called buyer builder agreement, where Supreme Court has directed all the states, not Supreme Court, directed to the central government to say implement this buyer builders agreement in accordance with the law. That means to say that there is a standard buyer builder agreement which should be followed by all the promoter, all the builders for every real estate project. As Section 4 mandates every aspects of that real estate projects to be available on the RERA website, and those information should be given at the time of RERA registration. That means to say that this information is available even before the project is launched. This is also a transformation in the real estate industry. Have you ever imagined there would be a separate bank account for the purpose of the project? Have you ever seen any business for that matter? There is a separate fund is dedicated, earmarked to complete any business transaction. Have you seen this in any other industry? No, except the real estate industry. Of course, the real estate itself is a different industry itself, because you need a money, because what you're selling is ideas, what you're selling is the future delivery of a product. For that you need a money. That money has been having collected that money from the customers. It cannot be used for any other project other than for a specific project. So with view of that, Section 4.2 LD of the Act has been brought in. There is a separate bank account for each project. Out of which 70% of the money should be deposited in the respective bank account for a specific project. Friends, remember that this is a project bank account, not a promoter bank account. In case of a development agreement, joint development agreement, landowners are different and the builders are different. So landowners' money and the builders' money should be deposited into this bank account. There is no exception to it. In a subsequent slide, I can explain in detail about this provision. Section 4, again, the money having deposited, it just can't be used without intervention of you as a chartered accountant. You are the ultimate professional to issue a certificate to a promoter to withdraw the money from that project. Having collected, having deposited, how he can take this money back is only by way of the chartered accountant certificate. So friends, don't underestimate your caliber while issuing the CA certificate under this act. This is the only statute which has given a power to the chartered accountant, wherein their own money is allowed to withdraw without a chartered accountant certificate. So hence, please ensure you and I justify for my professional in terms of the knowledge and also the professional requirement to issue the certificate, duly exercising what is required under the Act. Section 11, online information available. Friends, there was a time where a promoter used to send one architect certificate stating that 5th slab of a project is completed, pay 30% of your money. and I do not know how do I verify that letter, how do I ensure that this really a fifth floor is casted, what do you mean by a fifth floor and what is a fifth slab, whether 30% of the project is completed or not. I did not add any information. Of course, few builders with the good practices, they use always to communicate to the customers with the photographs, with the note of what is a project development, but not all. Now, RERA section 11, rule 15D of Karnataka has made it mandatory that quarterly updates. What is quarterly updates? Quarterly update quarterly update which includes what is a sold, what is a unsold, what is the money collected, what is the money receivables, how much you completed development of programs, what is a pending. So that means to say, sitting at outside country, sitting inside, sitting from my office, I can know what is the progress of the project and whether every progress which is having at the site is at par with what they have promised in the agreement of sale. Friends, section 11 mandates the schedule of payment, schedule of the work. What do you mean by schedule of work? Have you ever heard that whatever be the practice was, when I will complete the project, the date when I complete the project was only a indicative, only a date which promoter used to give in agreement of sale. Say example 2026 December 31st is where I'll complete the project, maybe with a 6 months of grace period. That used to be a standard documentation, standard date. Friends, section 11 mandates now schedule of work delivery. What do you mean by schedule of work delivery? Log into Karnataka RERA website. You can see that starting date to end date has to be completely divided based on the schedule of work. When is my foundation start? When is my foundation end? When will I start my tile work? When I complete my tile work. Do I get the water connection? Do I get the electricity connection? Entire aspect of the schedule of work is part of this act. Have you imagined, have you come across any builder could have thought about it? Consider, unless if it is a big builder where they have a good project management team, where they do work with lot of consultant to capture every information of it. A small and medium, have you ever thought that he will think when he will do the excavation, when he will put the slab, when he will get into a bore water, when he will get the electricity connection? No, this is something which is of a very important aspect of it, wherein schedule of work is also has been mentioned with the dates on which it would be estimated or expected date to start, expected date to complete. That means to say I have complete information about the movement or the progress of the project. This is a transformative legislation, which is a transparency, which is accountable. So this is all which brings the efficiency in the project, efficiency in the working, efficiency in the development of this industry. The objectives are achieved or not on as can be voted, can be verified by each of this paragraph which is on the slide, which is very well prepared by Ramesh sir. And thank you sir, you bringing very important aspect of the RERA itself, which is a very fundamental. Not many have appreciated and also understood in a true sense. Next, mandatory mentioning of RERA registration number. Developers have to mention RERA registration number each of the advertisement and prospective. Section 11 mandates a RERA registered, because we all know that every industry have their own way to represent. Like FSSA, food industry, they should have the food license registration, or similar to that, mutual fund should have the mutual fund registration number. Like that, every industry have. Why not this exception of this industry? Why there is an exception to this industry? So every project has a RERA registration, and every project registration should be displayed on every advertisement. For the number one, the benefit is the allottees, the customer can be rest assured the project is registered with RERA. The moment I have a registration number, I can go back to the RERA website. I can look into the information which is published in the RERA website, and whether the information, whether the marketing, whether the sales talks or sales information which are given by the company or the person is same as what is mentioned in the RERA website, which enables the customers to take a informative informative and informed decision in terms of while booking or buying any of the property. Equal treatment to the home buyers. Friends, have you experienced this post RERA? It's a transformative legislation or not? You should only tell that. Prior to RERA, what was the builders buyers agreement? Was the agreement for sale was mentioning? Can you recall yourself? In case of a delay of delivery of any apartment, 5 rupees per square feet of super built up area. Consider 2000 square feet with a 2 crore rupees of my investment I made on 2000 square feet, and they say 5 rupees is a delay in terms of delivery. 2000 into 5 is 10,000 rupees. In case if we delaying this project of 2 crore rupees of one unit, is willing to pay 10,000 rupees. However, you used to mention 24% as a delay interest. 24% delay interest in case of a delay payment by the customer. Was it in same plotter? Was it in a same fair transaction? No, this act as clearly mentioned now, both are under the same, both are and transaction should be very fair and transparent and accountable, and the maximum rate of interest for that delay should not be more than SBI highest marginal cost rate plus 2%, say about 8 to 9% in absolute number. If I delay my payment of my installment, I'll pay 9%. If you delay your apartment, you also should pay 9% of that delay. Is it not a fair? Is it not a transformative legislation? Friends, here as a professional, we have a highest role to play, and we as the professionals to protect the financial aspect and the sustainability, the feasibility of the every real estate project. We should tell the client, stating that if he is not on track in terms of the completion of the project, you should tell that if you delay it, you will be at very risk, and the cost of delay is very high, because 9% is a very huge, friends. 9% is a very huge. Every 2 crore rupees, you end up with paying 9%, which is almost equivalent to the EMI of the housing loan. Say 100 apartments, if you believe, started paying EMI to each housing loan, what would be the fate of this project? What would be the financial viability of this project? Ensure this is to be advised to our clients, stating that in terms of a delay. So when he plan, when he mention the end date, when he promise the end date, when he promise the customer that this by within which I'll complete the project, and he should be prepared in all aspects, the physically prepared, mentally prepared, financially should be ready, and he should have all the ecosystem to support him to complete it. Failing which, he'll end up with the compensation, which is of the interest, which is section 2ZA, again, which takes us to the interest component. And also 11.4e, friends, there is association of the home buyers, association of the allottees of the project. Now it is earlier it was the wisdom of the professional or the knowledge of the builder or maybe the home buyer used to form the association. For that matter, now in Karnataka we are clueless. Now also we are clueless under which act I should form the association. Karnataka Apartment Ownership Act 1972 still exists for me, and wherein by part B is something called association bylaws. Alternatively, I have an option to go back to Cooperative Societies Act also to form the welfare association, not welfare, allottees association, buyers association. So RERA mandate 11.4e, and also which also takes to the section 14, wherein it mandates the moment majority of the bookings are happened, the promoter shall invite or enable the allottees to form the association. It is enabling the allottees to form the association. That means is inviting, please come now form the association. The reasons are multiple. Why is enabling to form the association once the 51% booking are done? Why? The reason is section 8. When the section 8 is invoked under the act, in case of a project to be taken over, in case of a lapse of registration or not delivered within the time, wherein buyers or the allottees will get a first right of takeover, first right of refusal. That point of time there should be an association to, in order to facilitate that, act has really taken care and mandate the moment the majority of the bookings are done, it is the promoter responsibility. Section 11 mandates the functions and duties of the promoter. Level 4E mandates him to have the association in place. Section 14, is it not a transformative legislation? Is it not something which is accountable legislation? 14 talks about change or modification of the plan or a specification. If you come across any of the agreement of sale prior to RERA, was there any option? Was there any opportunity for any of the customers to talk on in case of any change? There was no. They used to say that in the future, if you acquire the TDR, additional FSS, I can build additional floors. And customers do not have any right to ask in terms of any of the changes which I made. Friends, now under RERA, it is clear now to the builders also, promoter also. The moment he think about the real estate project, it should be clear what is that he is delivering it to the customer. There is no confusion for the builder also, whether should I go to the additional TDR, additional FSI, buying after 3 years, where even government is clueless when he will release a TDR. And you know the TDR mess in Karnataka, what is happening. Even the government is also responsible for in last 2 years TDRs are not released. So what will happen to the builders community itself? So friends, remember, now this act is made it clear, and the promoter, the builder, the businessman should know what is he developing and what is he delivering it to the customer. The day one, he should know what is he delivering, what is he developing. With this, there is a certainty of a business to the businessman also, a builder also. You know that this is where I should travel without any deviation, without any additional frills to it. Now customers also know that, and regulatory also know that this is what is delivering it. Is it not a peace of mind to the builder also? Is it not something which brings clarity to the builder also without having any diversion? Only a focus for him to deliver what he has promised, what he has thought in the initial stage itself. Section 14 mandates any change in the plan, any change in the specification in the project, go back to the customers, take their consent of 2/3. Say 66.67% of the consents you take it, then you modify it. Is it not a transformative? Is it not a transparent legislation? Refund in case of delay, section 18. In case of delay, and the delay is due to the promoter not able to deliver, there is an interest. The interest already I have mentioned what is the rate of interest. SBI plus MCL, 2% MCLR. From the promised date till the delivery date is the interest which is under section 18. Friends, you have seen various complaints are filed before RERA across India. Maybe about 1 lakh cases have been filed, and most of this project, you can say 95% of the projects are filed before RERA for the purpose of delay of delivery of a project. You might have experienced your own project, your friend's investment, your family investment, or maybe your client investment. How much is a delay in terms of the project? You have also seen every day there is that builder, this builder, NCLT, NCLAD, government has taken over insolvency. Because of what? Because of the delay in delivery of a project. The section 18 taken care sufficiently. 59 to 70 is the penal provision. Friends, whether you say anything to the client or not, this is the important aspect under RERA. Without fail, you should tell the clients. Even for you to practice, don't start your after reading section 1, come directly to the 59. Section 59, you read it. 59 to 70 is the penalties. Friends, under RERA, penalties are huge. Authority can become a part of your profits, partner for the profits. The meaning is penalties are huge. You haven't seen this much of penalty in any other legislation till now. Maybe 100 rupees per day, 200 rupees per day, 5,000 per day. No, authority is very clear. Legislation is very clear. In case of any non-compliance, authority has a right to impose penalty up to 10% of the project cost in case of a registration, non-registration and marketing. In any other non-compliance, 5% of the project cost as a penalty. Imagine 10 crores is the project cost. If you have marketed, collected money from the customer without knowing, then 1 crore rupees, up to 1 crore rupees, you can levy a penalty. When that penalty should be paid? Even before registration, even before you market officially launch the project, you should pay the penalty. Friends, in Karnataka, penalties are levied by the authority in earlier days. It's a huge. I personally have seen that penalties are as high as 1.8 crore, 2.3 crore rupees. Imagine a project of 2.3 crore rupees, pay a penalty and start his business. How it would be? What would be the experience of the builder? What would be the experience of the customer? Friends, the information of levying of penalty, payment of penalty would be reflected in the website, would be certified by a chartered accountant stating that what would be the penalty paid. Is that a good thing? Absolutely no. So as a professional, it's our duty to educate every customer, educate every builder, every promoter of the project, penalties under the act. If you are aware that these penalties are very stringent and very strict, please come into the business, do the business, or do the business which is mandated, not otherwise, because it's an online application. Everybody can see that what's happening in the project, and compliance is the utmost important, very important aspect of this legislation. I'll tell you here, authority will not come to the builder. Honestly, I'll tell you, that is what is the today's situation. As of today's situation, authority don't come to you. However, authority, if they come to know that there is a non-compliance, penalties are mandated. All your customers in the project, all your stakeholders in the projects, are the people who will watching you always, is a watchdogs for throughout the project development and completion. Authority is the last person to come, but every customer, consider you have an apartment of 100 units, all your 100 unit customer, all 100 customers are like, they're completely watching you, and they are the people who will raise the alarm to the authority stating that there's a non-compliance in the project. The moment non-compliance, section 59 to section 70 will trigger. So this is the implementation report. Ramesh sir, if you are available, you wanted to talk about 2 minutes about this implementation status and also the CAC, role of CAC, and there is a structure of a central advisory council. If you have a time, you can explain, otherwise I can continue, sir. Okay, I'll take up this implementation status. Friends, you all aware that this is a central act. RERA Act is a central enactment, and powers are given to the state authorities. Powers are given to the state authorities to implement, to notify the rule, and also monitor and regulate it. But still the central act, we all know as a professional, rules cannot be expanded or it cannot be beyond the act. So still rules can be only a subset of the act. So in virtue of that, and the central government also wanted to have the a committee wherein the members of each state authorities could be a member of it. With the view of that, there is something called Central Advisory Council. Section 48 of the Act says Central Advisory Council, where the Housing Ministry itself is the chairman for this council, and most of the other stakeholders, other state stakeholders, and also the buyers forum. If you see that Fight for RERA, that is called FPCE, Forum for People's Collective Efforts, which is the largest buyers forum in India. So they are also part of this advisory council. So they are look at the overall implementation of RERA across the states. And this is the latest development, latest statistics of the implementation as on 7/5/2022. There are 31 real estate regulatory authorities. That means all the UTs and the states has already been notified or working it. And appellate tribunals already we have. And also adjudicating officers are already there. And all, as I mentioned, that this is one of the legislation where the authorities are also clear that it's an online web portal mechanism. Section 3 is very mandated. In the section 3 or section 80, it is also mandated. Authority as a function to operationalize the website for the purpose of its functions, and also to provide the registration, other aspects under RERA. So presently about 80,000 projects are there, about 62,550 agents are there, and about complaints are there, about 92,000 complaints are disposed under this. So this is the recent development and recent statistics of across India. For the Karnataka, I will present you in other slide when I come to the Karnataka. This we all know that there is a recommendations of the COVID. Most of the states has given, even though COVID is not a force measure, but government felt it to state this as a force measure and given some extension of the time for the completion of the project, 6 months, 3 months, and second COVID about 6 months. As I mentioned that 13 see Central Advisory Council section 41, there is a Central Advisory Council. Recently, as recent as 12th April 2022, we, Central Advisory Council had a meeting under the chairmanship of Hardeep Singh Puri, who is the Housing Ministry's chairman, Housing Ministry. Housing Ministry is a chairman for the Advisory Council and also a Minister for Housing. So also they have discussed on various aspects of it. Friends, we know that this being the central act, states are mandated and they have taken a cognizance of West Bengal and Telangana. Even though act is rules are notified, there is no full-time authority. There is no permanent authority which is exist. And also builders needs to provide a certification of structurally designed building. The reason is we had a couple of cases, couple of incidences where the buildings have not fit or structurally was not good. So advisory council has taken the cognizance of making this as a mandatory document. Accordingly, if you see the Karnataka RERA, structural stability certificate is one of the mandatory document in terms of at the time of filing the registration, telling that the engineer or architect gives the drawings or whatever be the construction which are drawn, which structurally is structurally which the building take care of the structure wise. On completion, while filing the completion, it is a mandatory document to submit the structural stability certificate of an engineer based of the building. Also, the Association of Advice for Voluntary Certificate Rating of the Builders, and this is one of the, if you read the section 32, authority as a mandate, authority as a function to do in terms of the grading of the project, which is nothing but rating of the project, and grading of the project itself is on various parameters. Andhra Pradesh was the first state to announce the grading of a project on some parameters, but subsequently because of the division of the state or division of the capital, that was become a last priority. But however, UP has appointed KPMG or PwC to come out with a white paper on the grading of the project, how the rating of the project. However, they have submitted, but it is not yet implemented. And this is what is the important outcome of the Central Advisory Council meeting. And also the ministry, the council clearly mentioned RERA, no state should dilute the act itself, and which is very mandated, and also state central government and also Supreme Court has clearly directed center to give a report of the dilution. In case of a dilution, they have to come back with the which is within the ambit of the act. So this is the important aspect. If you are the new if you are a professional without had any knowledge on RERA, whatever I have mentioned is the very tip, very small point of it. Is a lot of things that is there under the act for somebody to understand and appreciate the intent of the act. Friends, today I'm talking on this subject because it's not about my knowledge, because the act has so much of stuff, the legislation has so much of stuff, it has so much of power within. So that's why I'm able to talk to you before you. It is not about my experience, it's all about this legislation itself. So now let's go to a very important and must and should know about a few Supreme Court cases or the other High Court cases. I'll share you a few about it. What you had on the Supreme Court of India and constitutional validity of RERA. About 40 different petitions were filed before different high courts. Then when RERA was enacted, when RERA was notified, and Supreme Court felt it to transfer all these petition or writ petition before the Bombay High Court, and also directed the Bombay High Court to decide the matter within 2 months. This is a very important judgment. It's called Neel Kamal Realtor Suburban Private Limited versus Union of India, and writ petition 2737 of 2017. And if you read this article, apart from that, it's challenging the Article 14, that's a fundamental 19(1)(g), 23 and A, of course. It challenged every aspect of RERA, each and every section of RERA itself. If you ask me, entire RERA Act is challenged by the various stakeholders, stating that which is constitutionally invalid. And within 2 months, the High Court has held all the provisions of RERA is constitutionally valid, directed to register the ongoing projects and comply with RERA. No exception. Straight away at the Bombay High Court, having heard the various councils, legal councils, it's clearly said it's a constitutionally valid. Friends, you have to see who are all the councils who represented this before this Bombay High Court. All the councils who are represented are highly educative, highly knowledgeable. Most of them are senior legal counsels. They could not win over this act, and except section 43, none of the sections are agreed. All are constitutionally valid. That is what is the outcome of this. So this is the one more Ashwini Upadhyay. This is the to bring. This is what I'm talking about, the buyers builders agreement. Supreme Court directed the union government to prescribe the uniform agreement and also uniform rules. It's a PIL by Ashwini Upadhyay, where Justice Chandrachud and Suryakant has directed the Union Ministry and Housing Urban Ministry to let the states to follow the model laws, which is already there. Why they wanted to reinvent something new? Because when the act was enacted, central government has given the model draft of the buyer builders agreement, that is agreement of sale. Let them follow it. Why they wanted to modify something? So this is what is the recent Supreme Court directions to the central government, and central government in terms to all the state authorities. You also know that, as I mentioned, that West Bengal initially, when the RERA was in place, West Bengal did not go with the RERA Act. They had their separate West Bengal housing and Regulation Act, something HERA. It is WB HERA. And in 2020, the FPC is called Forum for People Collective Efforts. This is the earlier it called Fight for RERA. They had filed the before the Supreme Court, stating that WB HERA should be repealed or should be removed, wherein we have a central act. When there is a central act, state act is not should be a subset to the central act, not above that. So with that direction, Supreme Court has clearly told WB HERA is not valid, not constitutionally valid, and directed the Supreme Court to accept the central act and also implement the state rules. Accordingly, West Bengal has notified the West Bengal RERA rules in 2020 itself. However, still we have to authorities are not appointed by the West Bengal RERA. The 43 is also Pioneer Urban, which is also a very Supreme Court 2019 Pioneer Urban case, which is also has discussed the various intricacies of the act. And it is and if you are practicing in RERA, friends, you have to read important judgment, the Pioneer, the Neel Kamal, the Simi-Sikka of Haryana High Court, New Tech Promoters Developer, which is the recent in 2022 or 21. So these are all the very important Supreme Court, where it talks on various aspects of it. And also Supreme Court has clear the gaps in terms of understanding the act or the requirement or the intent of the legislation. and has clearly pronounced the judgments, and which also say about, and the outcome of is called retroactive application of RERA, because many have filed an application stating that the RERA is a retrospective legislation. The Supreme Court has clearly mentioned it is not a retrospective, it's a retroactive legislation. That means to say that we are not taking out any project which already completed, only a project which is incomplete as on date of RERA implemented. That's as on 1/5/2017, the project have not received the completion certificate, project is not complete, then only those projects are included. So projects launched prior to RERA but still continued, that's a retroactive effect. And also under 43(5), when the order of the authority to be appealable before the appellate tribunal, it is mandated that 100% has to be remitted by the appellant. So this was a very difficult, very challenging for, especially for a promoter, especially for a builder. Instead he remitting 100%, he could have been settled with the customers itself. However, this is what is the act mandates, and also accordingly the Supreme Courts and the courts are also held. Whether single member of RERA may be delegated powers to RERA to pass the order, because if you strictly reading of the act, act has mentioned RERA authority. The moment RERA authority is, because the composition of the RERA authority is one chairman and two minimum members. This is a composition of RERA authority. The function of the RERA is always vested with the RERA authority. That was the one of the questions before the Supreme Court, and I'll discuss you in Karnataka RERA about that. Accordingly, the Karnataka also has implemented multiple benches for the multiple benches post Supreme Court order. As I mentioned, three bench has.
Sir, I think this you can scroll over, because
Yes,
we
sir.
have already discussed about all the 5 issues.
Okay.
We have given detailed PPT on this, so let us not discuss,
Okay, sir.
so that it becomes self-sufficient for the people to read later. Therefore, we have kept it. So go ahead.
Okay, sir. Yes, sir. Sir, yeah, any of you are here, you wanted to talk about this writ petition 43?
No, we will see. Issue number 1 is, just go back.
Yes, sir.
Issue number 1 was next.
Issue 1.
Whether the act as a retroactive application. Okay, all these 5 issues you have just said now. Okay,
Yes, sir.
go ahead. Retroactive application.
Yeah, retroactive application, sir. Yes, sir.
So the High Court said, whether the act as a retroactive effect, it said all ongoing project will have a retroactive effect. But where there is a completion certificate, then it is not. Now the controversy is there. Number of judgments have come from different courts. High Court says if there is a Bombay High Court says if there is a occupation certificate, they don't require to register with RERA. But now another judgment of contrary judgment has come from another High Court. That is, I think, Bihar. So there it has been said that occupation certificate is not complete. So there has to be completion certificate. So therefore now contrary judgment has come, whereas Supreme Court has already said that in order to say that project is completed, there has to be completion certificate. So wherever there is no completion certificate, then that has to be registered with RERA and it will have a retroactive effect. Yeah, next. Power vested with the authority. Yes, there are 2 authorities, as you are rightly pointed out. One is the adjudicating officer, another is the authority. So what are the things which can be done by the adjudicating officer? That is nothing but compensation. Compensation for adversity in the advertisement. Secondly, change in the plan without consent, or changing the authority without changing the promoter without consent, or delayed possession, or there is a defect in the title, or any non-compliance, or any of the rights of the allottees are violated under section 19. So any loss is incurred, that can be decided by the adjudicating officer. However, the authority has all the other power to grant the refund, interest, everything. But adjudicating officer does not have the authority or the jurisdiction to grant the refund and interest. Next. Next. Yeah. Power of the authority under section 81. Yes, it has been held that under section 81, the RERA can delegate its power to anybody. So even they can delegate it to single member. That has been upheld. Next. Pre-deposit. Yes, if at all the promoter wants to file an appeal, only for the promoter, it has been said that the promoter has to deposit 100% of the money which has been awarded by the adjudicating officer or by the authority, whether it is related to principal, interest, compensation, everything has to be deposited 100%. Whereas in the case of penalty, the authority can decide 30% to 100%, whatever the appellate tribunal decides, unless until that money is deposited, the appeal is not admitted. So whereas for allotee, there is no such condition. So the promoters said it creates a inequality, though it was upheld by the Honorable High Court in the case of Nilkamal Realtors Private Limited versus Union of India. Still, it was challenged in the Supreme Court, and accordingly, Supreme Court has again upheld that 100% deposit has to be made. Next. Last is there was a mistake in the drafting under section 40, which is related to execution. If you read the section 40, it was saying that in order to execute the order, compensation and interest, the authority and adjudicating officer or appellate tribunal can recover by arrears of land revenue. There was no mention as to deposit. So therefore, deposit or the money deposited by the allottee to the promoter. Then if the order can be done, but there is no execution possible. So therefore, Honorable Supreme Court said there is something called, the court observed that there exists visible inconsistency in the power of the authority regarding refund of principal amount under section 18 of the Act. And therefore, to this ambiguity was removed by the Honorable Supreme Court and said, yes, we are rectifying it. It needs to be rectified. So the amendment has been done. Next. So with this, this is a very good judgment. Now I request Vinay to take it forward. Thank you.
Thank you, sir. As I mentioned, this is one of the landmark judgment under the RERA, where which one prevails, whether IBC prevails over RERA or RERA prevails over IBC. A little background to it. A few of the home buyers have approached the IBC stating as a financial creditors while the RERA is in place. The question was raised under 58F. Is the home buyers are also included as financial creditor or not? So this is a judgment about Pioneer Urban Land Infrastructure, Writ Petition 43. And finally, it was held that yes, IBC is prevails over RERA. However, we also have to observe in what sense it has been done and what was the consideration when the judgment was passed. Maybe few we can see that even though the statute have been enacted in the same year, but RERA is somewhere in the month of May enacted and IBC 6 months later. And when the IBC was enacted, and obviously IBC could have taken the cognizance of RERA is in place. Hence, because both the act talks about in case of any inconsistency with any other act, IBC prevails. In case of RERA, RERA talks about in case of any inconsistency, RERA prevails. So this is what is both the act enactment, but our IBC is the subsequent act than the RERA. So IBC took a cognizance and the orders was passed stating that IBC prevails over RERA. However, we should see in terms of the practical aspects. Also subsequent to this, also I think IBC has also have made it a point that minimum 100 home buyers required for somebody to file an application before IBC. So these are all the very important judgment, very notable judgment for somebody to read it in case if one is practiced in RERA and also even IBC also for that matter. So this is what is the RERA is to be read harmoniously uh, with the code. In the event of conflict, that the code will prevail over RERA. Concurrent remedies to the alert is Consumer Protection Act, RERA triggering the code. So this is what is the um, outcome of this judgment. This is also one of the important judgment. Friends, we all know that like Section 3 mandates if 500 square meters or more than eight apartments is a mandate. If you strictly read the act, both the conditions should be satisfied for the project to come under RERA. However, authorities are felt if any one condition to satisfy, those projects should come under RERA. This is the Geetanjali Aman Constructions, which is the Mumbai. Very good judgment where authority has directed and also levied a penalty on this promoter, stating that it is more than 8 units even though it is less than 500 square meters. Of course, this is now before the High Court, and still we have to see the outcome of this High Court. If the High Court says strictly reading of the act, if you read the strictly reading of the act, both the conditions should be satisfied. Hence, whatever the order passed by the RERA is not correct, then we have to see the what would be how the steps should be taken by the authority, or maybe whether RERA will go against the order of the High Court to the Supreme Court. We should wait and watch on this. So these are one more important and important judgment of LODA, where up to 40th floor they have constructed and received the completion commencement certificate, because this is more prevail over Maharashtra. In Maharashtra, there is a concept of obtaining the occupancy certificate floor wise, where in Karnataka we have a building wise. There they can obtain the occupancy certificate in the floor wise. Relating to that, whether it is to be considered as ongoing or not, that is where is this judgment is all about. Lavasa Corporation is also in case of a long lease. If you strictly read of the act, the definition of a project is for the purpose of sale or lease. The moment the lease is also included, then whether the lease, what do you mean by a lease, how to be arrived at, even the 5 years of lease is also should be considered for the purpose of RERA. There is a good judgment which is of Lavasa Corporation versus Jitendra Jagdish, Tulsiani and others. Because this lease is about 999 years, it would be definitely amount to a sale and thus covered under RERA. Because in Maharashtra, in couple of situation where promoters were very big promoter approached Tamil Nadu RERA. Tamil Nadu RERA has declined that lease is not applicable in this case. The reason is we have to see what you mean by lease under RERA. How that impact, how does affect the lessee under RERA? Because as we know that this enactment is to protect the transaction between a promoter and a customer allotee. In case of a lease, the transaction which is in guise as a lease, which has an impact on the allotee, the interest of the allottees are at risk or at task, then those projects can be brought under RERA. So the reason is, say somebody entering into a lease of a 1 crore property by paying 10 lakh rupees need not to come, where 99-year lease is given, 1 crore property in case of a sale, 95 lakh rupees in case of a lease. Yes, those properties to be comes under lease. Still not many cases have been reported by the authorities itself. Not many have come to the authority also, because in a very few cases there would be a concept of long lease. In case of an industrial unit, this is the Maharashtra. Similarly, there is a GMR versus Tamil Nadu also there. Why industrial units are not comes under RERA? Because Strictly reading of the act is not having an industrial, but the moment industry also something like a commercial. In my personal view, industrial units which is meant for sale, like a Karnataka Industrial and Development Board KIDB, should also part of this RERA. The moment they say that they're developing a project which involves a land and a development activity, and they should comes under RERA. This is a very simple example. A BDA, Bangalore Development Authority, Mysore Urban Development Authority, they are also developing a layout. Why, when they are included specifically, why not the industrial units? Why not the industrial units to be included? So this is in case of accountability of a professional. Friends, this is very important for a professionals to understand in terms of architect has issued a wrong certificate stating the project is completed on visiting by the on filing a complaint by the customers or allottees stating that certificate which are issued by the architect is erroneous, which is not correct. The certificate, as per the certificate, the work or the development activities are not carried out. Then there was a joint inspection, and wherein architects or action was taken against the architect for issuing a wrong certificate. Similar case also happened in Tamil Nadu RERA also. And for your information, Tamil Nadu RERA, the architect who issued a wrong certificate, he ended up with killing himself by suicide. So friends, and similarly, there is a Gujarat RERA also has issued a certificate, Shokan certificate to the chartered accountant for wrong issuance of certificate for withdrawal of the funds. We play a very important and vital role under RERA. The reason is all these certificates may be available to the public or the home buyers. So the moment is available to the home buyers, every home buyer will look into with the lens. So look at that, what's happening and how the certificate have been issued. So this is the first appeal, and interest and delayed possession for 1 year and action against the architect is a subsequent to that only. In case of unregistered projects, so we also come across very many cases where there is a unregistered projects to be considered for the purpose of listening, hearing the complaint. In various states have taken a various stands, and basically if the unregistered project which is not complete and liable for registration, then those complaints are also allowed. This case is Ferrari Hotels Private Limited. This order September to display the sanction plan. This is also one of the important aspect. Friends, various authorities have issued a guidelines or a directions either by notification or a circular or by way of regulation, wherein the sanction plan and specification shall be displayed at the project site. So in this case, they have not displayed it, so penalties were levied, and there was a question how this can be done, but however it is upheld that penalty is liable to pay penalty. So we should also know that in terms of the delay in delivery of a project, there is a levy of interest, and by act it is mandatory, and along with the principal and interest due to delay in over the possession as per the agreement for sale, and it is very clear, and also act is very clear, there is no exception to it, because the promoter must have mentioned the timeline, the end date in the application at the time of filing the RERA registration, and also has provided the completion handing note in agreement of sale. So this is one more, because as I mentioned, section 13, which says about 10% is the maximum amount to be collected as agreement for sale. Here the RERA for allowing the deduction of 20% of the agreement value by the promoter as per registered agreement. There is a anomaly in the sense, like one should understand the concept of RERA, because RERA talks about cancellation or forfeiture of the booking amount in case of a cancellation by the allottee. So that is what is the mandate under the act, and In case the allotee voluntarily cancel, then the promoter has a right to forfeit the booking amount. So what is the booking amount? One, we should see that the moment agreement entered, it is no more a booking amount. At max, the promoter can call 10% up to 10% as a booking amount. That is what is section 13 also talks about. More than 10% is agreement for sale. So what can be forfeited is only a booking amount. That means up to 10%. Even though your agreement for sale says about 20%. However, we should see that whether agreement for sale will prevail or the RERA prevails, and it's a retroactive enactment and the legislation. And in case of agreement entered prior to RERA, whether the clauses of the agreement prevails over the RERA. So this is again the Supreme Court builder challenged the NCDRC order which had allowed the allotee to exit with interest as even though OC has received before the complaint was decided. OC was delayed as 2 years against agreed possession date. And of course, with the interest, NCRDC is nothing but National Consumer Redressal Council, and which clearly mentioned that interest is eligible. They can claim the interest in case of a delay of the project. And as I mentioned that builders buyer agreement is something which is a standard in nature and which is not a one-sided agreement. And all these cases what we have seen earlier could be ended, and there cannot be a conflict of all these aspects when there is a standard agreement for sale which is to be followed by all the promoters and the builders. So for them to follow, professions, as we as a professions play a very vital role in terms of educating them, advising them, asking them to follow strictly. Friends, as you all know that this industry doesn't require a qualification. It is not like a doctor to become a open a hospital. Like it is not somebody who can only start operating the real estate project. Anybody and everybody can become a builder. Everybody can become a promoter. So who will educate them? How do we educate them? How do we tell that this is this play a very important and very vital aspect in terms of taking a decision, which may be a financial aspect or it may be a legal aspect. We as a professions play a very vital role in terms of advising the client. So this is the disclaimer class of Ramesh sir. Sir, if you are available, you wanted to say something on this. Okay, so this is a presentation of the Ramesh sir. I'm only here to read and explain about the presentation. The entire presentation was prepared by Ramesh sir on the subject till whatever we had. Now we'll go to my presentation. Before I move on to my presentation, from the institute, is somebody is here. I wanted to listen. I wanted to hear any questions from the participants before I go on to my presentation, sir. Can you allow the participants to talk? I have seen couple of questions which are posted. I do not know where to see those questions before I take up to the next one. Can I, from the institute, can I invite the chairman or a secretary or the operator to raise the question or share the questions which are all asked by the participants?
Sir, chat questions are there, sir.
Okay, 1 second. Okay, I'm just looking at that. Okay. Now can the participants can talk or they only can chat?
Chat, sir, chat.
Okay, fine. Chat. Yeah. Mr. Vijay Kumar Janadri has posted a question. Hello, sir. A company has developed a residential layout on its own land and selling sites to customer only on completion of the development of the layout. Whether RERA registration is mandatory? Mr. Vijay Kumar, the answer is yes. Answer is yes. There is no exception to it. This is the very standard question. Every we come across in every session. Maybe out of my 200 plus odd session, none of the session ended without this question. The answer is yes, yes, yes. The reason being is under RERA, whether you market the project before development or after development, RERA registration is mandatory. However, you will register the project before you go and market it. So you need not to register on the day one of plan sanction itself, but whenever you decide to sell it, then you can go and register it, sir.
Yeah. I just want to say here, Vinay, you have deliberated, given my presentation very nicely.
Thank you,
I
sir.
really compliment you. And I think the participants have now come to know that most of the controversial issues have been settled not by one judgment or two judgment, series of judgment by various high courts and also by the Supreme Court, appellate tribunal. And therefore now, because of these judgments, even the builders or the promoters are now cautious, and they are also taking a appropriate remedial measure. Now, only one thing which is now pending, which of course will be settled in the course of the, maybe in another 1 year or 2 years. Lot of ongoing projects which are registered with RERA, they have not been able to complete the project because of the various intervention of the various legislation, and of course happening of the money and various issues they were facing. Now, how to complete this project? In Maharashtra, we have nearly 5,000 projects, which are RERA registered projects, which are not completed. Similarly, in various states, you'll get at least 10 to 20% of the ongoing projects, which are not getting completed. The builders, there is a dispute, there is various legacy. And nowadays, the trend has been the landowner terminates the developer and then appoints a new developer. And the buyers are put high and dry in spite of RERA registered project. And Bombay High Court has given a judgment, unfortunately, that once the promoter is dismissed and terminated, the allottees do not get the rights on the land and the project. Therefore, this has become a little, burning issue. And I think Gujarat RERA has taken a proactive step in this regard. And UP RERA also has taken 1 or 2 projects. Maharashtra has also done few projects, but they're all putting onus on the association allottees. They are not putting the onus on the RERA itself. Section 8 of the RERA clearly says, if the project is not completed, it is the authority who has to stamp it and get the project completed. So, this also is going to give a lot of professional opportunity for us, and one has to look at it and do it. Now, of course, central government, as you know, the Swami Fund has been introduced, and because of the Swami Fund, 25,000 crores Swami Fund for stress project. So few of the projects are also been completed, and again, only RERA registered project they are giving the fund. So I think overall, in days to come, RERA will further strengthen itself, and it will give a lot of opportunity to chartered accountant. And I would suggest that it also will help you as a network practice. How it helps you as a network practice? Because I may be expert in auditing, so you take up audit. I may be expert in internal working, then take up the certification work. Then both of you can share. Then one person may be expert in your group litigation, so give him the litigation work. So there may be somebody who is very good in compliance, so give him the compliance work. So this way, if you are able to do the networking, I think that will make a lot of difference. And in days to come, I'm again saying, just to give you only 1 minute, sir, I am not getting, free at all because of this RERA. Every day, I am appearing before appellate tribunal or before the authority, or I am preparing a counsel for the High Court. So things are happening, and every day there is some issues. Every day there is complaints, and in days to come, as the litigations are and controversies are settling, more and more allottees will come forward and file the complaint, and it will complicate more and more and better transparency. Thank you very much. Yeah, I think you can go ahead with your second presentation.
Okay, sir. Thank you, sir. Thank you. And I'll I will close this and I'll open the other presentation, sir.
Meantime, there is one question in the chat box. I'll
Yes,
just
sir.
try to take it.
Yes, sir, please, sir.
Yeah.
Is
So-
the presentation visible?
Yeah, presentation is visible. Now there are
Oh.
some questions.
Yes, sir.
Okay, 1 minute. As a developer, we ask the customer to come and form the association, but customers are not coming forward from the association. What is the remedy available to the developer? Very good question. I do agree that the law provides for registration as soon as you complete more than 50%. If they are not coming forward, what you can do is, as and when you are selling the flat itself, you can take their signature required on the formats or on the association formation consent, so that once you reach 50%, you can go ahead. Because what happens with us is, as we sell the flat, whenever you ask, whatever signature you ask, they give. But when you enter into an agreement and thereafter you need some confirmation, it becomes difficult. So by giving an informed decision saying that it is required under RERA, so your signature can be taken. Now if they are not doing, you can make a complaint, because in the duties of the allottee under section 19, it is very clearly said that the allottee should also cooperate in formation of the association and convince. If they don't cooperate, you can also file a complaint against the allottees who are not signing, and then department, the authority will definitely direct them to sign. If they don't sign and complement the order, of course there can be imprisonment and a penalty ranging up to 10% or 5% of the cost of the flat. As a developer, you ask the customer to come forward, and so in that I think I have answered. Though there are a lot of penalties that are proposed under the Act, in practice, enforcement of at the ground level is low. Is there any need to strengthen the Enforcement Act? Yes, the RERA is upcoming, and the RERA does pass the order. Implementation of the order is also with the RERA under section 40 and of course 41. However, the RERA do pass an order, then they issue the recovery warrant if they don't comply, and they forward it to the district collector to recover the money under the land revenue code. That is where things are happening little difficult. Now, therefore, central government under the advisory council, which Vinay has already explained you on 12th April 2022, has already decided that to form a panel. And of course, we have given few suggestions, and if those suggestions are implemented by the government, I think it will make difference. Now, what are the suggestions? The first suggestion that we gave is, let the authority at the time of passing the order only say that the order should be complied within so and so date, and they should file an affidavit of compliance of the order in the order itself, and that affidavit should be filed on so and so date. Let us say on 1st January 2022 they have passed the order. Compliance has to be done within 45 days. So 15th February 2022, you write is a compliance and give the date. Now we don't have to make a separate application for execution of the order and then take the time. So within 45 days it is not done, then pass the penalty order under section 63 that every day of delay for not complying will attract, let us say 1,000 rupees per day, 2,000 rupees per day, whatever. Then third suggestion is that if that is also not met, then the RERA can appoint somebody, or even the RERA can direct to disclose the assets and liabilities of the promoter. Now the promoter at the time of registration has given various bank accounts and other details. So they can be asked to disclose the assets, bank account, all that of the partners, promoter, everybody. Now thereafter, if they don't disclose and other things, appoint a executive officer Now, who will be this executive officer? Because who executes the order? Tahsildar. What we can do is retired officers of the revenue department can be empaneled as a recovery officers, and they can be appointed the similar to SURFACE Act, where the people take the position and the district collector appoints the advocates as a court commissioner to take the position. Same way for recovery also this is possible, and they know the process under MLRC how to recover. So this, if it is implemented, I think it will make a lot of difference, and by way of rules it can be done without amending the act. So I hope the central government housing minister will take it seriously, and in days to come it will be done. Otherwise, this representation which we have done will definitely take it to the Honorable High Court and see that writ also will be done, so that there is mandamus where the direction can be given to the government. Thank you very much.
Thank you, sir. Thank you for answering the questions. We'll go to the other part of the program, and which is especially for the Karnataka and the latest updates on RERA, what we had now, important High Court or Supreme Court judgments also had, and let us go through the latest updates on RERA Karnataka. Friends, most of the participants are from Karnataka, and as I mentioned that each state has its own website and own way of functioning and own way of implementing and issuing the notification or circular. And in Karnataka, maybe latest update means I may go and travel back to 6 months or maybe the more than that also, which are very important even now for us to understand and appreciate the intent and objective behind it. So broadly, let us look at what is the latest statistics, what's happening in Karnataka. What we have seen in the first is all over India. And also next is we had something like 13th October 2021. All of a sudden on 14th October, there is a new module which has been there for the registration. What happened to that? And also there is a Lok Adalat notification which is there in 6/4/2022. Of course, you keep frequently looking at that type of notification. Agreement for sale, builders buyer agreement, and we'll see that where is that and how Karnataka has adopted this. Supreme Court direction to center to implement about that. And also for real estate agent, we have seen section 9 and 10 and what Karnataka said about the real estate agent. Section 6, project extension of time. You may surprise that why we are discussing again section 6. Friends, what we have is RERA is what we have. We have to see what is there in RERA and what is the recent practices, recent directions, guidelines by the authorities. Then the additional benches, that's again already we have discussed, that was the Supreme Court order, and what Karnataka has done in order to take the benefit of the benches. Section 8, lapse on lapse of the project date, what's happening and how authorities are looking at that. And also a list of advertisement which is violated advertisement guidelines. And also two important and very sensitive certificates which are notified, and those are applicable to a chartered account. Earlier, what we had was a Form 4 for a quarterly update to withdraw the funds from the project designated bank account in accordance with the Proviso 1, Proviso 2 to Section 4 to LD. Now something called 4CC has been included. That a 4CC is a completion certificate by a chartered accountant, and also Form 1, Form Registration 1 has been notified. Very sensitive, very sensible information and very apt information. Actually, if you ask me, these certificates are very apt. Earlier, whatever be the certificates we were issuing, we were not aware that what to mention, what not to mention, whether what we are mentioning is something which is giving some value to the reader, something which a reader are understanding what I'm trying to certify it. With this format, at least now the readers has some sense, some knowledge about what I'm certifying it and the reason and the intent behind it. So these are statistics of Karnataka RERA. So as of now, about 5,000 plus 5,833 projects applications are filed. It's a very notable. So maybe Karnataka is at the 4th or 5th position across India after Maharashtra, Gujarat, UP, and Karnataka, or maybe Tamil Nadu. So we are at the 5th position. We are maybe having about 7%, about 8% share in the entire India in terms of the projects. And in terms of the registration, you can say second largest registration of agent after Maharashtra. After Maharashtra, Karnataka is the second largest state to have the agent registration. Complaints also, Karnataka is maybe a fourth largest in entire India to be registered number of complaints. 6,623 complaints. That means so much of complaint were filed by the customers in the project, or maybe a promoter in the project on the allottees, vice versa. So I was mentioning about what is the latest update in Karnataka. Like on 13th October 2021, the module which were having the RERA registration module, whatever we had earlier, undergone change. And from 14th October, if you see the filing and which are made, wherein the additional information which were seek additional the information which were earlier used to collect in bunch, now they're bisected and asking in a detailed wise. So this is one of the important aspect as a professional we should aware when we advise to the clients. If you are not filed any application last 6 months or 7 months, you may not be aware of it. If you have already filed and involved in terms of filing the application, that you must be experienced of this. So it's very important, where earlier we had a post registration as a separate module. Like after registration, we used to enter various data during the post registration. Now those information is brought back into the registration module itself. Earlier intention was, this was a new legislation asking complete data at a time, maybe something which create a difficulty for a promoter, a hardship for a promoter to provide. So they cut into two pieces, the registration, the post registration. Now they're clubbed into single one, and now it's only a registration, post registration. Please note that the information which is there is very exhaustive and require accurate information to be provided. Section 4 mandates and also Rule 3 mandates, Karnataka rules. And these are all the documents which are all insisted during the registration. Friends, if you come across the information or document which are insisting by the authorities for the purpose of registration, it's a very exhaustive and also which very apt. If anybody come across the information which is department is asking is not something which is not as per the act rules of, maybe some other states are not asking so much. Karnataka RERA is very clear. Whatever they're asking as per the statute itself. Go back and read section 4. Go back and read rule 3 of the Karnataka RERA. Whatever information they're asking is completely which is as per the act and the rules. And broadly, the information which we all aware that the information which were received by RERA is about these things. Revenue or municipal records, whether it may be a municipal records or revenue records of the project property, including the conversion orders, including the change of land use. Next is the legal title ownership of the project land, which may be acquired, self-acquired, or maybe you got a right through a ownership by way of JD or GPA or any other mode where you got a ownership into promote the project. And also a title report, advocate title report, because section 4 and rule 3 also mandates the title report. A title certificate should be given by a legal or advocate having 10 years more experience in the real estate. Subsequently, the Town and Country Planning Department is asking for information relating to the sanctions, NOCs, plan approvals. Engineering department is looking at what is the sanctions, what is the sanction, what is the building, what is the sectional plan, what are the various drawings, specifications in the project. Whatever you are giving is all in relating to the approval itself, because we come across that the project which talks about a penthouse. It's the concept of penthouse is is very much existing in the Belgaum. Belgaum, when the Belgaum authorities issue the plan sanction, they say penthouse on the project. However, if you read the plan, in the plan, they may, in the sketch, they have a penthouse, and when they're writing is penthouse is not considered. So these are all the anomalies or differences we have when compared to the plan and actually what we are submitting to RERA authorities. So those things are verified, and queries may be raised by them to seek for a clarification. Of course, account department look at the KYC background, financial statements. Friends, here very important is UDIN. UDIN is a very mandatory document where our institute also has communicated to all the RERA authorities, stating the authorities to insist on the UDIN number on the documents or a certificate which are issued by the chartered accountant. So accordingly, the authority is insisting to provide the UDIN number on every document which every certificate which are issued by a chartered accountant. And the legal draft, as I mentioned in the earlier discussion also, these are all the mandatory document, and all has to be drafted, all has to be in accordance with RERA Act. It cannot be travel beyond Act. Example, 20% is the booking fees, and 20% once I collect, then only I'll enter into agreement for sale, not permitted, because 10% is what is section 13 mandates. So in terms of the any other conditions or the terms of the agreement cannot be beyond Karnataka RERA rules or the Central Act. So this is what is the important aspect. The department is the RERA authorities are verifying while granting the RERA registration. You may ask whether they were they not verifying all this earlier. They were verifying earlier also. Now the process of verification has taken to the next level, and unless all these things are all matching to other documents and authorities are not issuing or not granting the registration, I hope most of you have experience in this if you are practicing in RERA. 32G, section 32G talks about authorities has a function where they have to facilitate amicable conciliation of disputes between the promoters and the allottees through a dispute settlement forum set up by the consumer or promoter association. So section 32G, which itself talks about like authorities should facilitate the dispute resolution mechanism. Of course, Karnataka also has a conciliation and dispute mechanism. Authority felt it would be more effective if it is rooted through the Lok Adalat. You all know the impact and the importance of this Lok Adalat. Hence, authority is putting various steps and measures to call upon the customers, call upon the builders, where there is a difference of opinion, bringing them together before this Adalat, where the retired high court judges were the part of this panel, where they, if they both are come to a conclusion with some of the terms, some of the agreement, they themselves become one compromise, then they write a compromise there itself, they pass a order accordingly. The moment order is passed, it's binding on either party to accept that. So it's a very good invite. I heard that in every time they have this Lok Adalat, there would be about 200 to 300 complaints which are settled and agreed by both the parties. It's a very good move. Earlier also I have explained about this buyer builders agreement, which is refer back to Rule 8A in Karnataka. So a little background about it. Even though Karnataka has notified the rule, this agreement for sale in 2020, it is called Karnataka Real Estate Regulation Development First Amendment rules, and also subsequently about this, the Rule 8A inserting stating that Annexer A is inserted after Form I to the said rules. That is nothing but your agreement for sale. So this become a mandatory document in RERA, and as I mentioned that there was a mandate from the Supreme Court wherein that Justice Chandrachud said that it's already existing, already agreement is existing. Why are you going reinventing new agreement? You just follow it. Accordingly, Karnataka is also following it, And friends, if you are experiencing that, many of the queries which are written by the authorities while filing the application for registration, stating that agreement of sale is not in accordance with the rules which draft which is notified, and they're asking us to resubmit the agreement of sale in accordance with Rule 8A. And till it corrected, authorities are not granting the registration. What is the impact of this? What is the impact of it? That means to say that the agreement of sale which is entered between the promoter and the allottees of the project, which is already in the website, when even prior to marketing, prior to sales. That means customer can go and understand what are the terms of the agreement and what is the details which is provided in the agreement. Even number three, even the builders are also clear that this is a document which I will enter into agreement. There is no further disputes or difference between the customers and the allottees. For the authority also, it is very clear, this builder for this project, this is the standard agreement for sale, he enter into a customer. So now everybody is agreed, everybody is known that what is the agreement for sale for this project, the copy is already available in the website. So you may have some questions, practical questions. I know that like somebody has already put it in a chat privately. So one is about like, sir, do I have an option? Do the promoter has an option to modify this agreement of sale, having uploaded into the website? The answer is yes. The reason is in case of any requirement of modification of agreement for sale by virtue of whatever be the mandate of any other statute, so he end up with modifying it. But however, it can't be beyond act other rules. Again, I go back and say that it can be permitted to modify, but it can't be beyond the act and rules. What are be the provisions of act and rules? Very important to note that. So in what are the circumstances or situation the agreement for sale can be modified? Any circumstances or situation which require for the promoter to modify, where allottee should agree for it. It cannot be a one-sided agreement what we used to practice earlier. So it cannot be a one-sided agreement. So it should be agreed by both the parties in the of the transaction. Next is, can I go and change my payment plan which is mentioned in the agreement for sale? The answer is yes, because in the same agreement itself, it provides the promoter has a flexibility, promoter has accepted and passed on the additional benefit or additional discount to the customers on various grounds in case if he pays well in advance. So by virtue of that, there is a flexibility in the change of plan also in the agreement, except in the two aspects. Before agreement for sale, before entering to agreement for sale, he cannot correct more than 10%. Apart from that, subsequent installment, it's up to the allottee and the builder to get into an agreement and collect the money and also pay money. So any questions on any other questions on this agreement of sale? Of course, we as a chartered accountant, unless we practice extensively on real estate or advise on the clients on the legal aspects, we may not able to comment more on that, because advocates who are the professions who are play a very vital role in this. Next is on the real estate agent. Friends, we all know that Section 9 and Section 10 mandates the registration of the real estate agent. Also, they have a functions and duties to be performed under the Act. Even though Karnataka is the second largest registration, second highest registration of the real estate agent in India itself, but still the authority felt many of the agents are carrying on the business, carrying on promoting the real estate registered project without RERA registration, and those projects, those agents require registration under the Act. And this notification has been released on 30th 3 2022, wherein it mandates all the real estate agents to register before they market any real estate projects. What happen if they promote a project without registration of real estate as a agent under that? There is a penalty or consequences under section 62, where the agent is something they have to pay up to 10% of their money collected from the as a commission towards the up to 10% of the unit cost as the penalty for non-registration, and they promote the real estate project. So 5% up to 5%. Sorry, this is a 5% for the agent. And also it's a mandatory for the real estate promoter. There's a builder. Even builder has a mandate under section 11. He should not entertain any of the agent who is not registered with as a real estate agent with RERA. In relation to that, as an annual audit certificate, if you read the annual audit certificate, which is issued in form number 7, where the promoter, where the chartered accountant should certify wherein all compliances under the act has been complied with. If you're strictly reading of that paragraph, we may not able to certify Form 7 because Form 7 has two information. One information about money collected and money withdrawn, money incurred and money withdrawn. However, in the first paragraph, if we strictly read of that paragraph, it talks about all compliances under the act has been complied with. And also we are certifying with that. Soon there may be a new certificate format for the annual audit by the authority by incorporating all these aspects. One more important aspect about this also, if you issue the Form 4CC, the completion certificate, there also it is mandated by a chartered accountant to provide the year-wise commission which are paid to the real estate agent. And also in the post-registration module, now it is a registration module, you can say that list of agents under this project. So if you read, put together all these, and cumulatively, if you understand that real estate agent registration is a must. Number 1, promoter should not entertain any of the real estate agent who is not registered with RERA to market the real estate project, registered RERA registered project. He should not pay any commission to any agent unless he is registered with RERA. Even the RERA agent should not promote any project which is not registered with RERA. So there is a both the side. The registration is a mandatory, agent registration is a mandatory, and also payment of commission to only to a real estate agent who is registered under RERA is also mandatory. So any questions here? Any questions to anybody? Now 2017 to 2022, the registration valid for 5 years. Now already even the registration of the agent renewal also will start soon, because authority should give 3 months prior application. If you read the rule, I think rule 9 or rule 10, it talks about agent should file an application for renewal 3 months prior to lapse of their registration. So somebody has registered in the month of July or August of 2017, their due date is now for them to renew the registration of agent. One more is in the Central Advisory Council also, it has been placed by the Realtors, this agent association. Please allow us to market with all over India registration in one state. We do not know how the mechanism work for it. Next important update is on the section 6. Section 6, friends, it's extension of project. And as we know that there is a start date in the application and the end date in the application. That means when I start a project, when I complete a project, which is very much part of our registration application. The authority will issue a registration certificate starting from the start date or maybe a date of approval till the registration, till the end date as the validity. So if validity of that certificate is lapsed, that means to say that a promoter could not complete the project within that date due to various reasons, maybe market and demand, financial crisis, or maybe litigation by a landowner, or litigation by any of the neighboring side, or maybe some government order like NGT orders have come due to floods, due to rock hit in the by a foundation. So what will be the reasons which is other than a force majeure? We know that what do you mean by a force majeure, which is defined under the act, is an act of God. So force majeure, other than a force majeure, RERA doesn't give any extension. However, proviso 1 to RERA, where authority is of the opinion that this project require extension of 1 year extension based on the materials, based on the information which is provided by the promoter. RERA may extend, and maximum of that extension is 1 year only. So maximum of extension is 1 year only. So we have seen various projects which comes under extension. Maybe in Karnataka we have more than 1,000 projects which have filed for the extension of application for under section 6. And many of the applications have got the approval for extension of 1 year, and few are not able to get the extension for various reasons. And authority has taken a cognizance of hearing every extension, and during the hearing, authority collect the following information for them to assess whether the project can be extended by 1 year or not. So the detailed checklist is provided by the authority to the promoter of the project, about 21 different points. Those different points are very much important for the authority to decide whether the extension of the project under section 66 to be given or not. So this checklist also includes a professional certificate. Again, we play an important role as a chartered accountant. We play an important role by issuing a certificate stating what is the money collected and what the money incurred, what is the money withdrawal, whether that money withdrawal is in proportionate to the percentage of completion of the project. In case if it is not, then our qualification plays an important role, because proportionate completion of the project has a very vital role to play under the act. And as a professional, I should understand before I issue a certificate whether I'm issuing a certificate based on proportion development of a project. Okay, and certificate also including the borrowing details, cash flow details, sold inventory, unsold inventory, complaints against the project, or any litigation on the land. These are all the overall information the authority is collecting before they allow the promoter to before allowing the promoter to get the benefit of extension. Any query on the section 6 extension? Because on an average, I get 1 or 2 queries from our professional colleagues from different places asking, sir, this is what is the question by the authority and what should be our answer, what should be our reply, and if it is not fit into that, so what would be the action point and what should be your advice. So if any specific questions you have it, please let us know. And most of the other states, section 6 extension is automatic. That is a stand they have taken, like you pay the fees of what will be the fees prescribed by the authority, and also couple of certificate and the affidavit by the promoter. Based on that, you get a extension. However, section 6 extension doesn't give a liberty to a promoter for non-payment of compensation to the allottees. This is a one myth or one stand everybody is taking. Every promoter or or maybe some advisors are also telling that you got an extension of RERA, so you need not to pay the delay compensation. The answer is no, because agreement prevails over this, because you have committed this to the customer, stating that this is what is that you have committed to the customer, and you are still liable to pay the compensation. To that extent, authority is very clear. They are taking either 2/3 consent of the allottees, or go back and give the affidavit for section 18 stating that I am liable, and I'm accepted that I will pay compensation or interest for a delay in accordance with the agreement which I've entered with the customers. So authority is very clear on that aspect, where they collect the affidavit and also make aware that the promoter that with this extension of the certificate or extension of approval, promoter is not exempt from payment of delay compensation to the customers. This is a constitution of additional benches. Remember, we have discussed about the Supreme Court order stating that authority has a power. Authority is vested with the power under Section 31, where they can, in exercising its duties, under Section 80, in exercising their duties, they can appoint other to delegate the power under Section 81 to delegate the powers to others. So in exercise of those powers, Supreme Court have passed the order, they can delegate the powers. Because the challenge was in Karnataka is earlier authority has formed the benches and also heard. There was a PIL before the High Court of Karnataka, where few have filed an PIL stating that additional benches of the RERA is against the constitution and which was not permitted, but with the Supreme Court it is very clear that it is permitted. Accordingly, Karnataka has formed different benches with the authorities, with the members itself. One member bench, 2-member bench, and 3-member bench. So depends on the depends on the type of complaint, type of hearing. They have made it different benches. Also, friends, we should understand that we have one chairman to a member. This is the constitution of an authority. Strictly reading of the act, authority should perform A, B, C, D, E, F, G, H. If so, unless they have multiple people, multiple benches, they cannot perform. All the three cannot sit together always to hear a complaint. So what they did is they have a multiple benches. Each people can function separately and pass the necessary orders. Accordingly, there is a 6 different benches which is formed, which is there in the Karnataka. This is also a recent one about in March 2022. This is the constitution of benches. Remember, one of the important aspect is the display of advertisement, display of RERA registration number on all the advertisement materials, which may be a advertisement in a media, social media, SMS. It may be a print media, it may be a hoarding, it may be a FM, it may be a TV. Wherever you say it, or it may be a telephonic call, somebody calls also, they should also mention this is a RERA registered project, this is a RERA registration number. RERA registration number is a mandatory across all. To that extent, advertisement guidelines are issued by the Karnataka RERA. How the RERA registration number should be displayed, what should be the size of the RERA registration, because Section 11 talks about such registration number to be displayed on the all the advertisements prominently visible. What do you mean by a prominently visible is a question itself. It's a subjective matter. Something prominent to you is not prominent to me, so it's a subjective. Hence, authority felt that there should be a guideline. The guidelines is issued by the Karnataka RERA in terms of the advertisement, how the advertisement and how the registration number to be displayed. Top right side corner, and the total size of the RERA registration number should be equivalent to 10% of the entire advertisement material. That means 10% of your advertisement cost is towards the RERA registration number display. One step ahead, Andhra Pradesh RERA has traveled, where they have given a logo. What is a logo to be displayed as a RERA registered itself? So somebody look at that logo, okay, fine, it is a AP RERA registered already. Like that, each state has separate registration guidelines, advertisement guidelines for them to issue it. So Karnataka also has issued these guidelines. Also, if some of the project which is violated these guidelines, then either they are not registered, they are not display the RERA registration number, or displayed which is not prominently displayed, or display the RERA registration display not fully displayed. Somebody said PRM last 4 digits. We have RERA registration number like this. They are displayed only this much. So these are all the some of the violations of advertisement guidelines which is issued by RERA. For that, authority has issued the notice, and those notices are available in the RERA website. So if somebody goes and see in the RERA website, there is a list of projects which are violated RERA advertisement guidelines. Section 12 again, it's a veracity of advertisement, and it's a very important, what I can say is very critical section under RERA, veracity of advertisement. As I mentioned in the initial slides about the objective of RERA, and also which brings a transparency, accountability, standardization, and those things are also those things. If you recall yourself, section 12 plays a very important role. Veracity of advertisement, you cannot advertise what you not intend to deliver, and how true is that advertisement which you are displaying, how factual the advertisement you are giving it. Example, I'll tell you, if you see the advertisement material, 5 kilometers or 5 minutes drive to the airport. The moment you say 5 minute drive to the airport, what hits on your mind? It's very near, right? But if you take your car and travel, it may take 15 minutes. Then where is this 5 minutes? So there should be it's a subjective matter. Nearest to the international schools. What if I'm nearest to the international school? Your 10 kilometers is the nearest for somebody if you worked in Mumbai. If you are worked in Bangalore, even 1 kilometer is not a nearest to me. So that is a subjective matter. So the veracity of advertisement is a very important, and should be promoter should take a cognizance of whatever the advertisement material which is providing, and should be considered appropriately. And as I mentioned also, section 11 mandates the filing of quarterly returns, quarterly updates on the web portal of the authority. And we all know that due date which is mentioned in rule 15D, 15 days from end of each quarter is the due date for quarterly updates. And if you see that this is the quarterly updates missing in Karnataka, about 4,400 projects are registered, of which about 1,289 projects were not filed their quarterly updates. List of projects who have not uploaded quarterly updates progress. From where I'm getting this information? On the website itself. If you go and browse through the website, entire information of the promoter, project, business, everything is available. And this is what is important. And maybe you can look at your customer, look at your client who is a real estate developer, whether it's complied or not. Friends, the recent directions of a Gujarat RERA to chartered accountants mandates to include the non-compliances as part of their statutory report, statutory audit report. Refer back to the I think accounting section 143 or 144. What is accounting standard, sir? Is anybody can throw a light on me in terms of what is the accounting standard? Note on statutory audit on RERA on real estate. Have you seen this? Can you see my screen? Can you see the screen, sir? Section 143(9) mandates each auditor to comply with auditing standards as prescribed in Section 143 or 10 of the Act. So this is very important aspect for us to consider, to provide various risks which are associated with the project by way of audit report, which is mandated under Section 143(9) and 143(10) of the accounting standard through Section 143(9) of the Companies Act. So if you are a statutory auditor, the auditor should comment on the compliances under the RERA Act also as part of that audit report, and also any risks which are associated. any risk of non-compliances resulting into there may be risk of penalty should be highlighted as part of the project. And section 11, which as I mentioned that it is the various functions of the promoter of section 11. 1B is the quarterly update, and also rule 15D is the quarterly update. So you can see on the screen what are the information which is required to be filed as part of the quarterly update, which already have discussed earlier also, which is a very important compliance, very critical compliance by any promoter for that matter. And as a chartered accountant, I have an important role to play to file this quarterly update. Either promoter can file himself or it has to go through a chartered accountant. I don't think anybody else can take up this service, because we are the professionals who handhold the promoter or the builder or the developer in terms of their compliances. I don't think even advocate can take up, because this is more relating to the financial aspect and also a physical progress development of the act. A chartered accountant can be a good consultant for a promoter to explain on the quarterly update and importance of the quarterly update. And here is a catch for the every professional. When you give this quarterly update, which also including sold and unsold inventory, money collected, money as a money receivable, money received and receivables, balance receivables. So this is a quarterly certification. A chartered accountant gives it, which is available in the web portal of the authority. Can be accessed by any tax or revenue authorities, either GST or the income tax. And don't you think that we should reconcile with this with the GST? I've received one message in the chat box stating that, can you say in relation to GST how RERA? This is one aspect to it. While filing your GST returns, please ensure that values are match or reconcile with your RERA numbers. I don't say it should be matched, but it should be reconciled. There may not be a matching, because if it is matching, then there would be something which is not correct. Okay, in most of the cases, generally GST will have some other turnover. Stock transfer would also called as a turnover, but however, reconciliation is a must between the GST and the RERA, and which will save at later point of time in case of any penalty, in case of any show cause notice which is issued by the GST department. We come across from various authorities, especially the GST department, take the data of the RERA, say that this is what is your collected or collectible from the customer, and you have not remitted, you have not paid to the department GST. And we know that how this industry works, how this industry offer to tax. And also this is the industry, the GST liability is either on the advance or performance of some work, that is the agreement. Say slab number 5 is casted, that is what is your agreement talks about whether you raise a demand or not. The moment slab 5 is casted, your liability triggers. Consider if I am a GST officer, I just log in and see what is that liability, what is that, what is the terms of your agreement, terms of your agreement. In the agreement for sale, if you go and see that 5% booking, 10% on the agreement, 20% on the first slab, 35% on the second slab, 50% on the fourth slab. So I can see 50% of the money you should have been collected from the customer on casting the fifth slab. I go and see your progress of the project in the website itself. 50%, fifth slab is casted. That means to say 50% of the money should have been should be realized. If not realized, your right to collect money is there, and fifth slab is already casted, and it's duty for you to discharge the GST on the fifth slab payment, fifth slab casting on the total total sold receivables. Here is the catch, and please ensure that you should understand the impact of the RERA while you advising on the GST to the customer, your real estate customers. So this is important in terms of the quarterly update, and if you issuing the certificate as a chartered accountant for the purpose of RERA also, then you have a more advantage for you to reconcile, match the numbers between the GST and the RERA. Or if you are not a consultant for RERA, still you insist for the quarterly certificate which are uploaded in the website, or maybe take a login from the promoter, you can take the login and you can download the certificate and you can go through that information. And if it is not correct, then there would be a high risk of the promoter, high risk for the promoter in terms of the other liability of taxes. Next example is the income tax. We all know that recognition, revenue recognition. And the moment 25% of the project project is completed, then there is a revenue recognition is a must under the Income Tax Act. And for various reasons, prior to RERA, what we used to show is we used to show less than 25% so that I can postpone my revenue recognition. But now I have a CA certificate, I have an architect certificate, I have an engineer certificate. For the purpose of RERA, the more the percentage of completion, the more the eligibility to withdraw. Mean to say that invariably on quarter I should have been disclosed or certified based on the physical progress. Now at the end, at the income tax, the promoter may not have a choice to disclose or choice to declare lesser than what already they have declared to the RERA. Then either one is wrong, either RERA is wrong or certificate for RERA is wrong or certificate for income tax wrong. Friends, both certificates are issued by a chartered accountant. Either you may be issuing or your fellow member or fellow friend may be issuing. So ensure that whatever we issue should be reconciled and kept it in the mind. The income tax, the GST, RERA, amount which is declared to your banker as a sold, unsold inventory or raising the loan, and also for the purpose of insurance. Everything has to be uniform. There should not be anything which is left unreconciled throughout the project. Important subject is section 8. Section 8 is something which is in case of a lapsed project. Friends, we know what do you mean by lapsed project. Initially, we take the timeline for the completion of the project. Section 6 talks about 1 year of extension. What will have done after 1 year of extension? The project is called a lapsed project. There is no other recourse under RERA for them to extend further other than invoking section 8. Section 8 talks about the lapsed project, because why I'm discussing this is the latest trends at the authority also, at the market also, at the customer, at your developers also. They have filed some application stating this is the end date which I can complete. They could not complete because of the market condition, because of the various factors which has impacted. Demonetization, GST has come, COVID has come, prices of the material has gone up, rocketed, NBFC chaos, nobody is funding for a project. What else need for this industry to go down? I don't think any other factors which is left for this industry to suffer. Most of the things has already impacted or affected. Still, the promoter or a builder is surviving, is strong enough to survive in the future also. That is what is my prediction, because whatever damage need to happen already happened. There cannot be a damage beyond this to any of the builder. Or builder who already lost in between the battle of these things, he may not come back. Who are continuing the business, they'll survive and they'll survive better in the future. So the labs project which I mentioned is in terms of they could not complete within the timeline which they have given. Then section 6, even after 1 year of extension, there is no other way other than to invoke the section 8. So how do I go with the section 8? There is no standard way of following throughout the country. Each authorities has their own way of functioning, own way of invoking section 8. Application should be filed for section 8 in case of a lapse. It may be a suo motu also. Even the promoter also, authority also can issue a notice under section 8. The promoter can file and invoke section 8, invoke application, or the allottees also can come and file a section 8 in application stating that we will take over the project. The promoter is not unable to complete the project within the timeline which you have prescribed. Let me complete. Let me come with the association, group of individuals. You have purchased the apartment. I will take over the project. Invoke the section 8. Please allow us to take over the project. So this is called section 8. And as a professions, we have very important role to play. Nobody else can play an important role. nobody can play a better role than a chartered accountant, because I know what is the financial aspect. I know what is required under the for the purpose of project to complete the project. What is the progress and what would be the challenges in the project. If you are closely associated with the promoter of that project, you can be a better person to take up these services and file application under Section 8. And after having filed the application, that the authority is, if they have convinced the based on the representation of the promoter, they may pass a necessary order to allow the promoter to continue the project development till its completion with various conditions which is mentioned as per the order. This is a one way to look at that. This is the one way to look at that, where the promoter himself file application. As a promoter, I file an application. Other way to look at is where allottees, as I mentioned, that association, remember the association of allottees, when they should form the association, the moment majority of the bookings done. What is the majority of the booking? Maybe 51%. The moment 51% of the bookings of the apartment or the units in the project have been completed, the promoter should enable the formation of association. Consider the association is already exists. That association can file an application before RERA stating that project is delayed, which is lapse, registration is lapse, we will take over the project. So, and if the application filed by the allottees of the association or the customers of the association, then the authority also listen to that, and whether is it fair to give it to the association or still to consider the application filed by the promoter himself. So they will go through the advantage, disadvantage, and the fair opportunities given both the people, a customer association of the allottees and the promoter. And the finally authority will pass an order. It is better to give to the promoter who can complete it. Or if the promoter is not having any trust on the promoter, authority is not having any trust on the promoter because of whatever be the happening in the market, whatever be the delay in the project of any other project of him, then they may hand it over to the association of allottees. Association of allottees can take over and they can continue the project. What happened on takeover? Again, Section 7, where bank account would be operated by the association itself, and of money which is lying in the designated bank account can be transferred to the association. That is a subsequent. And also this is what's happening in Karnataka and other states also fairly. This is what is happening. And in my experience, we have appeared about half a dozen cases in terms of the Section 8, invoking the Section 8, and it's a good interaction, and authority is fair enough. Authority is completely aware of the project and also the aspects of how this takeover should happen in case of invoking Section 8 to the allottees. So what is Section 8? What are the things which authority may consider at the time of filing the to hear both the parties or applicant? Reason for delay in completion. What are the hardship faced by the promoter? As I mentioned, that whatever the hardship which they faced in last few years could be a hardship for them, which is real to the promoter. Also, they ask if it is to be given to the promoter himself to continue, and if it is given to the builder himself to continue the project, do you have a 2/3 consent, majority consent? Not 2/3, it's a majority consent. Section 8 talks about majority. Let me check that. Yeah, Section 8 talks about majority consent of the allottees. The first refusal, first right of refusal will be given to the allottees in the project. First right of refusal would be given to the allottees in the project. That means to say that while giving the opportunity for somebody, allottees, if you say that we are not capable of handling this, then they can engage somebody else. We'll also see that whether there is a sufficient cash inflow is there to complete the project. If there is no sufficient inflow, what will happen? Generally, in my experience, if there is a sufficient inflow of the funds into the project to complete, promoter will not give it. He will retain. He want to retain it. If there is no sufficient inflow, he may allow it to take over. Let it to go to somebody else, even to the allottees association also. We have seen both type of project where there is a sufficient cash flow. Promoter wanted to keep it himself and complete the project. Where there is no sufficient, he always in the mode of let go, let the allottees take over the project. In many cases, already let go happened. Allottees have come forwarded in order to protect whatever they paid money. They have took over the association, took over the project, and also they spending additional money for them to complete the project. Otherwise, whatever is the money already paid would also be lost. Example, they paid about 90 rupees to the builder and their liability is only 10 rupees towards the project to the builder. However, when they took over, they end up with paying 20 rupees. They needed 20 rupees to complete the project because of various reasons of material escalation or other charges which are due, or money is not utilized for the project by the promoter. So invariably they end up with paying 20 rupees, because to protect 90 rupees, they end up with paying instead of 20 rupees. That means additional 10 rupees they end up with paying, but still worth paying it to protect 90 rupees by themselves. So this is what is the market trend and what's happening around the real estate industry in terms of this. And all compliances under the act is also to be required. What is quarterly update, annual audit compliances, section 4 to LD, section 4 to LD compliances, complaints, section 18 complaints, or any compensation which are pending. This is a major thing which they're looking at. Agreement for sale, whether they're following fair practices or following the agreement of sale. These are all the major thing they are looking at. And only on satisfaction of all these compliances, they're allowing the promoter to continue the development of the project with the some terms and some of the conditions which they have laid down in the order. Of course, progress of the development in the project. So let us look at that. What would be the outcome of the authority order? They may permit the promoter or the allottee association, it may be a promoter or the association of allottee, to continue the development of the project and ensure that all compliance shall be complied. Section 11 is a very strict one, and that should be adhered at all point of time. In addition to everything, they may insist to submit a detailed monthly progress report, collection spending incurred instead of quarterly, or in apart from addition to quarterly, they also wanted to file it on monthly, because they wanted to monitor these projects in a close manner. So they may ask promoter to submit these documents on monthly basis. This is how section 8 works. This is what's happening in the industry at this point of time. This is the latest updates in Karnataka RERA. Friends, any doubt, any questions we have? We have another 20 minutes to go. It depends on the number of questions. I can take the subsequent sessions, subsequent slides. If I don't have a subsequent sufficient questions, I can take the subsequent slide, or if you have a questions, I can answer to question and answer all. Somebody has questions, request you to please cover GST aspects of RERA, which I already mentioned. Please ensure that there is a reconciliation between GST, RERA and income tax, which is always important. Dear sir, how to get ASR annual schedule rates to value the unsold inventory in certifying form? Basically, you can go to the website, you can select the schedule and you can see that, or you can ask the promoter to provide what will be the guidelines value for this project. He himself will provide it, sir. Next, can we consider the ASR rate estimated and given by the developer to value the unsold? Yes, you can give it, but you also ensure that ASR is provided, and generally it would be available in the website also on the stamps and registration department. Or if the ASR which is given by the promoter is fair, you can adopt that also. Next, any other questions? Any other questions we have? Otherwise, you want me to continue? I'll continue the remaining part of it. Okay, there are no other questions. Let's look at the important certificate which are notified by the Karnataka RERA. That's the registration 1, Form Reg 1. That's the CA certificate which is recently notified about 50 days back. And This certificate should be issued by the chartered accountant holding certificate of practice and providing few information about the project details. The reason for the authority to notify the certificate is to know the basic information at a single point. Rather, authority calling for various information from various as a various document, they are relying on, because chartered accountants are extension of the authority functions, where they can rely on the chartered accountant certificate and can consider the certificate is something which is of a importance to them and rely on those information which is mentioned in the certificate and allow the registration to happen. In that view, Form 1 has been notified. It's about 2 months which was notified, and it should be registered, it should be issued prior to registration. The certificate should be part of the registration application. If you read of this, there are very good information and also something which is of CA institute may not permit us to certify something which is also we are certifying it. However, with a note that these are all the estimates which are issued by some other professionals. And as a chartered accountant, institute is restrict to certify the estimates. So, however, this law requires us to certify it, but how are we certifying it? With the clear note that we are relying on the work of other professional, and based on that, I am certifying this. What all these certificate, this registration, one certificate contains what? Estimated cost of the project. What do you mean by estimate cost of the project? We all know that Rule 5 of the Karnataka RERA as define estimated of cost of the project, including estimated cost of the land and estimated cost of construction. What do you mean by estimated cost of the land? The land cost, either the acquisition cost or the guidance value as on date of filing the application, whichever is higher to be considered for the purpose of application. So this is what is important. For that purpose only, department is also, RERA also asking to provide the copy of a guidance value certificate at the time of registration. So as a chartered accountant, I exercise my duty in terms of collecting this information. So how do I collect this information? Maybe ASR value or guidance value, I can take it from the department, stamps and registration department. But the construction, how do I know that what would be the cost, estimate cost? Maybe we have to insist estimate cost of construction from the promoter through the engineer certificate. Engineer will give the estimated cost of the construction, that is the on-site construction cost. And apart from the on-site construction cost, off-site construction cost or the administrative cost, borrowing cost should be added to that to arrive at total estimated cost of the construction. So again, there is as a chartered accountant, I should exercise sufficient precautionary measure and also keep the backup of this information and as working papers before I certify it. Simple example, estimated cost of the project will say that interest cost of 10 crore rupees. How did I arrive 10 crore rupees estimated cost as part of the estimated cost? And 10 crore rupees is something which is to be declared, which should be briefed by the promoter. Unless he brief it, I may not able to provide the 10 crore rupees. How did I arrive at? Say an example, builder wanted to take 20 crore rupees loan at 12% rate of interest for next 4 years or 5 years. And also there is a 1 year of moratorium period and remaining 4 years of repayment along with the interest. The amount of this 20 crores paid over next 4 years at the rate of 12% amounting to 10 crore rupees as the interest over next 4 to 5 years. Consider if the sales are good in the first month or 6 months, you may not borrow the loan at all. So there is no borrowing, there is no borrowing cost to it. So what will happen to this interest cost? This is what is important for us to understand. Sufficient disclaimer should be given as part of the certificate which you end up with issuing it, and what is the source and what basis we have issued this certificate is also very important. So without which it's very difficult as a chartered accountant to justify this information, justify the certificate itself, cost itself. Next, the borrowing, which also I told, if the borrowing already exists, I can certify. If the borrowing is not there and it's a borrowing is at the future, should I mention it here? So these are important subject, important matter for us to consider that. Source of funds, on what basis I'm issuing the certificate, what is the source of fund for the project completion. So actually, if you refer to the Gujarat RERA has the detailed source of funds in case of a project cost is more than 50 crore. You have to give the detailed project report, DPR report, like banker insists the similar way. The Gujarat RERA also insists on the detailed project report, DPR. So here source of funds is like whether what is the source of funds for the promoter, either it's a own funds, borrowing funds, or other funds in case that also as part of registration 1. Designated bank account. Friends, we have seen that in Proviso 1 to Section 42 LD of the Act mandates the designated bank account, a separate designated account for each project. That bank account we should mention in this certificate. And how do I ensure this is a designated bank account? Obviously, I should collect the bank statement from a banker stating this is the designated bank account. And also please ensure the designated bank account you mention in this as a professional, it should be a 70% account. It's a 70% account, not 100% account. It's a 70% account is a designated bank account. That account detail should be given. Bank name, branch name, IFSC code, and the location. That is what is the information about it. Next, the promoter ownership details, and even though KYC details are provided as part of this, authority is unable to understand who is the promoter and who is holding the stakes in the project. In case of a proprietor, you know that in case of a partnership, there may be a partnership deed and how much money contributed is also available. In case of a private limited company, then the details would be available in the respective financial statements. And instead of looking at the financial statements, the authority is asking to provide these details as part of the registration 1 certificate itself. So very difficult to fill information in case of the various ownership is involved. Like recently we were filling one of the private limited company. The private limited company has the Series A share, Series B share, Series C share. So how do I mention the percentage of each? That is something which is the difficult. And of course, in a simple private limited company, you can pull out from the respective financial statements and you can put it. And other details which is mentioned under registration 1, Reg 1 certificate. So this is about the Form 1 registration CA certificate. Is a CA certificate should be issued at the time of registration, uploaded in the RERA website, available and visible on, to the promoter, sorry, to the authority. And this is a certificate should be issued by a chartered accountant holding certificate of practice, because there was a question which was raised: can the employee of the organization can issue a certificate? It is not, because you cannot generate the UDIN unless you are holding the certificate of practice. So UDIN is a mandatory as part of the certificate itself. And what we have seen, a registration we have seen, registration certificate we have seen, extension we have seen, lapse of registration we have seen, and various compliances we have seen, like agreement we have seen, modification we have seen in the first half, quarterly update we have seen, advertisements we have seen, modification of plan, association of allottees, formation of association in terms of the complaint, what happened, what would be the rate of interest. You pass on all these things and you are reached a completion. You are completed the project in accordance with the agreement for sale, entered marketing brochures or whatever the promises or specifications made. You complete the development of the project. What is the development? What is the definition of a development? Internal development and the external development works. Both are defined under the Act. Internal development is a development which is within the project land. External development is a peripheral part of the land. Maybe you have to lay a road to connect the main road. You have to draw a transfer power from the high tension wire from away. You have to draw a water connection from the main lane to your project. That is outside the project, that is called external development work. And whether those things are completed 100%, ensure that till 100% completion of this is not a complete. Mere receipt of occupancy certificate is not the criteria for the purpose of completion of project, because we observe many of the promoters say that we received the occupancy certificate, project is completed. No, whether you receive the project occupancy certificate or not, unless the project is complete in all aspect of its development work, physical development work is important than the certificate. Because in the state of Karnataka, especially in Bangalore, occupancy certificate would be issued at one certain stage. That means the building is built in terms of the sanction plan. Okay, then occupancy certificate would be received. Friends, generally in my experience, the occupancy certificate would be received by any promoter when he completes 70% of the development work in the project. That means to say, still there is a 30% work would be pending in the project. So that is not completion under RERA. Completion under RERA is 100% completion to all the activities. Internal work completed, electric work completed, water completed, lift completed, common amenities completed, facilities completed, parking is completed, plantation of trees are completed. Everything you should complete, say 100% against each of this activity or amenities, facilities, specifications, which are mentioned as per the agreement of sale, then only it is called completion. Because there is a definition in the RERA itself. Completion certificate, occupancy certificate. Occupancy certificate is a certificate where the moment there is a provision for water, electricity, sanitation is called a occupancy certificate. Completion certificate is a complete in the whole aspect of the development is called a completion certificate. Act recognize completion certificate. Act doesn't recognize occupancy certificate. This is the one more important. A recent, I think Gujarat High Court held occupancy certificate or a completion certificate, which one prevails for the project to include in RERA. This is in context with ongoing project. It is very clear. A court also held that it's neither a occupancy nor a completion certificate. If the progress of the development work is not complete physically, then the project is under RERA. Friends, one more aspect under GST, because GST is a very important. We also seen various advertisements or the marketing brochures. OC received, no GST. In my view, that is not correct. It is not the OC received. Completion certificate should be received for somebody to say that no GST, it is not the OC received. And you can go back and check in GST. Is GST referred to occupancy certificate or GST referred to completion certificate? If the GST referred to the completion certificate, come back and see what is there in RERA as a complete certificate, completion certificate. So authority, promoter or the builder may be sitting on a bomb in case if you consider occupancy certificate is a certificate to state there is no GST. Okay, however, if you collect the occupancy certificate and the development work is completed, I agree. If the occupancy certificate completed, still the work is not completed, development work, then that is not completion, still the GST works. How do department come to know about it? You received the OC as on 1/1/2022. In your books of accounts, still you are spending the expenses. After 1/1/22, you started collecting your concrete. After 1/1/22, you started purchasing the lift. After 1/1/22, you started applying for BESCOM. After 1/1/22, you started purchasing the transformer. Then where is the question of completion in the project? In the state of in the Bangalore itself, in the BDA, in the BESCOM will give you a power connection the moment you have a OC. Till OC you don't get a power. Then where is the question of the project is completed mere having a occupancy certificate? So please remember, even GST talks about a completion certificate, not a occupancy certificate. Why I'm trying to tell you is in terms of a completion certificate, somebody certifying the project is completed. Please keep remembering all these aspects before the issue of a certificate. This is the certificate again issued by a chartered accountant holding certificate of practice, and the details should be given since the inception of the project. Money realized is since the inception of the project till the completion. However, pre-RERA, post-RERA details should be given. These are money details has to be given in the application in the certificate. Also, this 4CC has very opt in terms of recognizing the formation of an association of allottees. In case if it is association is formed, under which act it is formed, under which if it is formed under say respective act, what is the date of registration, what is the instrument and registered before whom. And in terms of it is very common to collect the advance maintenance charges for the purpose of project, whether those money is with you or which are already transferred to the association. If it is with you, how much with you collected, how much you spent for the project, how much is available with you. In terms of not transfer the funds to the project, mention that the reason thereof. And in case of a borrowings, we know that most of the projects will have a borrowings. In case of a borrowings, that comes with the mortgage of the project land. If the borrowings are there, project lands are mortgaged, whether the project land is discharged, the hypothecation or a mortgage is discharged. If not, please mention the details about it. If it is discharged, attach a copy of a discharge deed. So mean to say that fairly this completion certificate has captured the real information which is required by the act, intent to protect the allottees and also bring the transparency, bring the accountability of the promoter in terms of discharging their duties under the act. So very important, as a chartered accountant, I should understand why this 4CC, why the chartered accountant certificate 4CC is important while I am issuing. Friends, this is a public document. Anybody can go and check this document. Please note the information which is available, which you are certifying is available in the portal of the website. I, as a customer of a project, I can go and check the certificate what you are issued is correct and fact. Because as a chartered accountant, I may not be visited the property before I issue, but your customer, the customer of a project, knows that the project is not complete. Project work is pending in spite of the certificates are issued. Please remember these are all the very critical aspect while issuing the form 4CC. Don't take it casually to issue the form 4CC, because I've seen in various certificate where the chartered accountant or friends have issued erroneously without understanding the intent of the act. Friends, these certificates are taken on record by the advocates while they are representing the allottees in the project for the before the authority, and also making chartered accountant as a party to the complaint, stating that the certificate which are issued are is not the factual one, which is wrong, erroneous. So there is the challenge. This is a letter recently which is written by Gujarat RERA to all the chartered accountants to consider the 143.9 and 143.10 of the Companies Act, and also look at the SA 250 and SA 315. Identify the risks which are associated and also report in the auditor certificate is what is that Gujarat has written to all the chartered accountants. It's the auditor responsibility to verify and report compliances status of all the relevant provisions of RERA Act and other significant aspects while submitting the audit report, specifically compliance with regard to RERA. So this is what is Gujarat has written, and of course, which is also have published, I think, which is also mandated under the Companies Act also, while we look at the while we issuing the certificate, and now it has brought by Gujarat RERA specifically written to the chartered accountants. And also they say that what are the other compliances, start from section 3 to section 19, all the compliances they've included, which all we have discussed throughout this session. So this is about the presentation for the today, sir. And now we are at 8 o'clock. I hope we have some time for the question and answer to the participants. Srinivas sir, over to you.
Sir, members, if you have any question, please you can ask. Sorry.
Okay, some of the
Questions,
one member has asked, sir, income tax will be part of the total cost. Sir, answer is no. What do you mean by a cost? Income tax is always a part of the profits. Income tax is part of the profit. It is not about the cost. So it's a tax on profits. It is not a cost, sir. Okay, cost is which very much defined under Rule 5 of the Karnataka RERA, and on-site cost, off-site cost, administration cost. The FAQ which is released by the Karnataka RERA and bank account direction specifically exclude the income tax, sir.
I think there is no other question, sir. We can conclude with your permission. Vinay, sir.
Yes, sir.
Okay. Thanks a lot, sir, for your time and efforts in sharing your knowledge. I thank Ramesh sir also. I thank all the members for actively participating and making this program successful. Thanks a lot. We look forward to many programs from you, sir. Vinay, sir.
Thank you, sir. Thank you, sir.
I request members to join for tomorrow's program, Issues and Controversies in Supreme Court's recent judgment on Section 148 of Income Tax. This is taken by Naveen Kariwal. Tomorrow evening, I request members to join for this program. Thank you once again, sir. Thank you.
Thank you, sir. Thank you very much, sir. Thank you for the opportunity. Hope the session is of useful to the members. If any feedback is given by the members, allow to accept it and allow to improvise on that, sir. Thank you, sir.
Thank you, sir. Thanks.
Thank you. On behalf of Ramesh Prabhu, sir, also I thank all the audience and participants for the patience hearing, sir.
Thank you.